being spoken to, my lord. Initially, my lord has dictated, my lord, interest in ECA matter, interest shall be paid by the owner. Then my lord has dictated that it should be by the insurance company since it's a motor vehicle policy. But in the final order, my lord, in the judgment, it came as owner shall pay the interest.
All right.
My lord, fresh matter admission.
The insurance company to pay.
Insurance company in the motor vehicles
Yes, policy.
and in ECA.
ECA matter. In
Yeah.
fact, my lord has corrected, my lord, but in the final order, my lord, it again it is. Please.
Fresh matter for admission.
Adjournments page wise. Page number 6, serial number 35 to 40.
Serial number 39 may be taken up next week, my lord. I do not have any papers. I am for the respondent. Do not have any papers with me.
39.
39, yes.
Request of counsel for
9th
respondent number
August.
2.
9th August.
Read is on.
Out 9th,
9th August.
9th August, yes.
ಯಾವುದು?
3467 of 22.
But
But
all
put
this
it, sir.
matter along with counsel list on.
9th August. Page number 7, serial number 41 to 46. Page 8, serial number 47 to 54.
Serial number 49, my lord.
Serial number 54, Mal. Next
Serial-
week.
Request of learned counsel for appellant. Your appellant.
Yes, Mal.
Read list on.
9th August. 49.
Serial number 49, my lord.
Yes.
But I was directed to take notice by your lordship on 21/3/23, but copy is not yet served, my lord.
Prasanna Shetty.
K.
Ele-
Prasanna Shetty.
At request. Learned counsel for respondent number 2. Released on.
9th August.
Copies to be served. On respondent counsel.
Page number 9, serial number 55 to 60.
My lord, serial number 56, my lord, yesterday's matter. My lord, I am not, preparation is not up to the mark, my lord. That is why next week at any date, my lord, next week at any date. That is the future funding ಬಗ್ಗೆ.
Request
Next
of
date at
appellant. Released on.
August.
ಎಷ್ಟು?
9th August, sir.
Much.
Page 10, serial number 61 to 67.
Serial number 64. Also connected MFA, my lord. 4298 of
For appellant, please.
2024, my lord. Claimants also filed the appeal, my lord.
Call this matter along with MFA
4298 of 2024, my lord.
of 22. Yes, list on.
9th August.
9th Bedason, 12th to 13th.
Before matter, yeah, after 2 weeks, madam.
Last.
My lord, serial number 59, my lord.
19th August.
Please.
Yavudu, sir?
Serial number 59.
Hmm.
May call next week, my lord. Not
At request of counsel for respondent. Released on.
12th August. Page number 11, serial number 68 to 73.
Serial number 72, my lord. I am for the appellant. Kind of next week, my lord. 72.
At request of appellant counsel, released on.
My lord, serial number 71, my lord.
Yes,
I have not received the appeal memo, my lord. Kindly call this matter next week.
72. ಯಾವಾಗ?
Direct the appellant counsel to furnish the copy.
71 now.
71. Learned counsel for the respondent seeks time on the ground that copies are not served to him. ಅಲ್ಲಿ ಕಳಿಸಿರ್ತಾರಲ್ಲ.
ಇಲ್ಲ ಬಂದಿಲ್ಲ sir. ಅದಕ್ಕೆ your lordship has directed me to take notice on 24/7.
Copy of the appeal memo to be served. to counsel for respondent. Call on.
9th August. Page number 12, serial number 74 and 75. For orders, serial number 1, Patel D. Karegowda.
Recurring question covered by insurance. Therefore, notice to respond number 1 maybe.
Dispensation. Notice to R1 is dispensed. Memo is accepted. List for admission.
Serial number 2, KV Shyam Prasad.
Is connected with the
19th.
Call this matter along with MFA number
409/21, my lord.
409/21.
21.
Registry to show the name of learned counsel D. Vijay Kumar in the cost list for respondent.
Much of it.
Call on.
And
22nd. Serial number 3.
direct the appellant counsel to furnish the copy.
Copies to be furnished. Notice to R1 is dispensed.
978 days,
Claimant,
978 days delay is there.
Lord, the appellants will not claim the interest, my lord, because at the time of accident, my lord, the
claimant's appeal.
claimant's
Yes.
appeal.
All right, work it.
No interest on delay period.
I1 of 21. Filed to condone the delay of 978 days in filing the appeal. Will stop being satisfied with the reasons assigned and cost shown. I deem it appropriate to allow the application accordingly. IA1 of 21 is allowed, delay of 978 days is condoned. This for admission.
22nd. 22nd.
Mobilized.
Serial number 4,
Madam, that claimant, appellant which shall not be entitled to interest for the delayed period on being successful.
4,
Second matter on 8th August, connected matter is posted on 8th August.
Yaudu?
MFA 1866/21 already connect ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ?
ಮೊನ್ನೆ Tuesday sir.
8th August.
ಹೌದು connected matter.
Call this matter on 8th August. What about R1?
ಅದಕ್ಕೆ ಸ್ವಾಮಿ R1 owner has also filed same address ಸ್ವಾಮಿ.
All right, call this matter on 8th August
ಮಚ್ಚು.
at request of appellant.
60.
Rangegowda.
Serial number 5, Rangegowda NR.
with MFA number 3123 of 2021.
This matter along with MFA
3123 of 2021.
3123 of
2021.
21. Call on.
22nd. Serial number 6, Pradeep B.
I'm for R5, my lord.
You're for R?
5.
5, AM Venkatesh. Hold on.
R1 and 2.
What about notice to R4? Weeks time granted to take out notice for R4.
And they have not deposited.
Go and file execution. Call on.
22nd. Serial number 7, Parashuram AL.
8th respondent. I am for the.
Ah.
The respondent,
What, sorry? Come to the mic, madam. Mic is provided for you. Why are you,
Apologize, my lord. I'm appearing for the appellants,
Ah.
requesting for a week's accommodation, my lord,
for what?
to take steps irrespective of the death of R1 and R2.
Who's R1 and R2?
Well, I'm only a proxy counsel, my lord.
Who's R1 and R2?
The R1, R3 to 6 are the legal heirs of R1 and 2. They were the claimants,
3 to 6.
yes,
Legal heirs of 1 and 2.
1 and 2.
And they are not required anymore.
ಅಲ್ಲ ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
Already LRs are.
Already on record. LRs are already on record.
They are claimants.
Claimants,
You are appearing for.
I am for the claimants,
So you affirm that no, there is no other LRs.
no other LRs.
Shall I take it?
Yes,
Learned counsel for respondent. Number 3 to 6.
3 to 6.
Sri Jagdish Baliga submits that R3 to 6 are the LRs of R1 and R2 and they are already on record.
Yes,
Hence, the notice may not be required. in respect of any to take notice may not be required further. Full stop.
R7 is the driver.
7 yaru?
The appeal is by the owner. And R7 is the driver of the owner, appellant.
Driver is required.
Not required. Alla, our mele liability ಇದೆ.
All right.
1 and 2 ಮೇಲೆ liability ಇದೆ.
All. Relist next week.
ಅಲ್ಲ ನಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ 36/2023.
List MFA crop
Yes,
36/23.
2023.
Call on.
Let them furnish the one copy please to me. The insurer in this case,
ನೀವ್ಯಾರಿಗೆ?
8th respondent.
ಅವ್ರ ಇನ್ಶೂರರ್ಗೆ.
ನೀವು ಇನ್ಶೂರೆನ್ಸ್ 8th respondent.
Yes.
ಹೌದು.
Copy to him on the next date.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಕೊಡ್ತೀನಿ.
Interim order may kindly be extended.
What interim order?
There's order of stay subject to a condition of deposit.
Have you deposited?
I'll have to take instructions on that, my lord.
The interim order will continue if you have deposited. Because of that, to the
Grateful.
extent. Interim order will continue.
Grateful. Much. Deposit has been complied with.
R1 and 2 are not husband and wife. They are two ladies by name Ningamma and Halamma.
One of the brother expired. So these are the claimants. Judgment ತೆಗೆದ್ರೆ ತಾವು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
No, in the judgment they were on record at that time.
ಹೌದು.
So if you are saying so, I will take it.
ಯಾಕಂದ್ರೆ ನಾನು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. In that cross objection only these respondent 3 to 6 are the appellants.
Yes. Call on.
Serial numbers 20 seconds. Serial number 8,
So grateful.
Chikana C.
Kandas. No representation. Relist next on.
28, alas, 22nd. Serial number 9, Vijay Kumar T.
Notice to R2 is dispensed. Council seeks a Universal Sompo. Yara B. Pradeep.
I will take notice, my lord. I will take notice.
Universal Sompo, you will take notice?
Yes, ma'am. Yes, ma'am.
Learned Counsel Sri D. Vijay Kumar is directed to take notice for R1. Registry to show his name, copies to be furnished. Call on.
22nd. Serial number 10,
For applicants, 1 week.
For R2, my lord.
R1, all of them.
Yenike.
Thanks.
Yenike.
Steps.
3 times already agogidya.
of such
Learned
person.
Counsel seeks time, relist on.
21st. Serial number 11,
I'm for respondent.
Notice to R1 is dispensed. Memo is accepted, full stop para. IE 1 of 22 is allowed, delay of 61 days is condoned. List for admission on.
22nd. Serial number 12, Pradeep P.
Who's R4?
Owner of the vehicle. Calling dispensation.
Notice to R4 is dispensed. Memo is accepted. Ready?
Claimants also filed 2 appeals, my lords.
All right, list.
5150 of 23, 3375 2000. Please, ma'am.
List these 2 matters along with this appeal. Call on.
22nd. Number 13, Marin.
As per the order of the Honorable Court, I have served the copies of the notice to the counsel of the respondent who are appearing before the trial court in execution number 84/24. The copies of the postal account has been served, Your Honor.
Nobody has come. You take out notice again.
The copies is served to the counsel of the respondent.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು?
Kindly interim order may be granted, Your Honor.
Who are you?
I am for the petitioner, RC owner of the vehicle. Attachment warrant has been issued. Yes, sir. Petitioner is the first petitioner, senior citizen. 4 lakhs has been awarded. 4,80,000 has been awarded. Attachment warrant has been issued. In execution number 84/24.
Delay is condoned or, notice ಹೋಗಿಲ್ಲ.
Yes, sir.
Pending consideration of IA number. How much is the delay?
Day 51 days, sir.
Huh?
51 days.
Consideration of IA number 1 of 24. IA number 2 is taken up by imposing certain conditions. There shall be stay, operation and execution of the judgment and award dated 10/11/23 in MVC 7131 bar 2019, which has been put to execution in execution petition number 84 of 24, subject to the appellant depositing 50% of the award amount within 4 weeks from today before the executing court.
Released on 23rd. Seal number 4, Pradeep B.
I am for appellant, my lordship. Regarding council submission, my lordship, office raised company seal, my lordship. Manager Magma General Insurance, HDI Magma General Insurance Company.
Huh?
Regarding office objection, my lord, council submission. Regarding seal, my lordship, Wakalat. Manager in trial court made party manager Magma HDI General Insurance Company. Company seal Magma HDI General Insurance Company. Seal not coming manager in forthcoming. That is the office of the
Wakalat.
Please, my lords.
Magma HDI General Insurance Company ಇದೆ. ಏನಿರ್ಬೇಕು ಮತ್ತೆ?
ಅದು ಕರೆಕ್ಟ್ ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಮ್ಯಾಗ್ಮಾ HDI ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಂತ ಮಾಡೋರೆ. ಅದನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ಮ್ಯಾನೇಜರ್ ಅಂತಿಲ್ಲ ಸೀಲ್ ಅಲ್ಲಿ ಅಂತ.
ಮ್ಯಾನೇಜರ್ ಇಲ್ಲ ಅಂತ.
ಹೌದೌದು.
Objection raised by the registry is overruled.
Insurance company challenging negligence, my lord.
Lord Leonard Counsel. Issue notice to respondents on main and IA pending consideration of IA number 2. For delay, IA number 1 is taken up by imposing certain conditions. There shall be stay of operation and execution of the judgment and award dated 16/2/24 in MVC 353 of 23. Passed by Additional Court of Small Causes, MSCT Mysore, subject to the appellant depositing 50% of the award amount.
Before this court, my lord.
For this court within 4 weeks from today.
Please, my lord. Much obliged.
On 28. Seal number 15, Benny Ravish.
Lord, office objection is United India Insurance Company correct ಹಾಕಿದೀವಿ ಅಲ್ಲಿ United Insurance ಅಂತ ಇದೆ judgment ಅಲ್ಲಿ ಅಂತ.
Objection raised by registry is overruled.
And liability, please. Entire amount is deposited before the executive WC commissioner.
Lord Leonard Counsel for the appellant. Issue notice to respondents. Counsel for the appellants has produced MMO for having deposited the entire award amount. ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
Tribunals.
For the
Immediately after the
trial court.
Is the original acknowledgement, please.
In consideration of IA number 1 of 24. I number 2 is taken up for consideration in view of deposit of the entire amount. There shall be stay of operation execution of the judgment award dated 5/1/24 in ECA number 27 of 21, passed by First Additional Senior Civil Judge MACT Chikmagaluru, subject to the deposit of the amount.
Entire amount ಮಾಡಿಬಿಟ್ಟಿದೆ already.
Right, that is your.
28. Seal number 16, Girish B. Baldare.
My lord, 1 week time may be granted.
Request of council relist on.
12. Seal number 17,
Any
Ravi Chandrasekhar.
discrepancy disposal year. Objection raised by the registry is overruled. The notice to respondent.
28.
Liability, please.
Liability.
Please. 50% apartment. Liability and also percentage of disability, please.
On time? On
Please.
time?
Please.
It's filed on time. What is on IA1? There shall be stay.
It's
of
in time,
operation-
please.
Operation and execution of the award dated 25/4/24 in MVC 68 of 22. Passed by Second Additional Senior Civil Judge MACT at Chikmagaluru, subject to condition the appellant deposits 50% of the award amount before
Before tribunal, please.
the tribunal within 4 weeks from today.
On 28. Hearing on IA, seal number 18, Sripad V. Shastri.
My lord, I am for appellant. Respondent filed an IA, my lord, to recall this judgment.
Since the company also filed an appeal in MFA 2963 of 2022, my lordship. At the time of the claimant's appeal, we have not brought to the court notice. The court is.
We have, you
You
are
are
not.
questioning the You are questioning the liability, my lordship. Hence, for the recall, I filed an application to recall and club the matter and dispose the matter. In same cause of action, we have also filed an appeal. Same, my appeal is pending before this court, my lordship.
What is the number?
2963 of 2022,
29/63 of?
22, my lordship.
My lord,
So this is appeal by the claimant.
Yes, my lordship.
So what is that still pending?
Yes, my lordship.
Why, that is your mistake.
And ಇಬ್ರು ವಕಾಲತ್
my lord, my lord, the recalling of this judgment is not necessary because as well as the liability is concerned, my lord, whole of the judgment, my lord, as no judgment is forthcoming, order is forthcoming regarding the liability. Liability is an independent factor. It is only a quantification. That is why that appeal is concerned, my lord, it may be independently handled. Tomorrow it may be posted. I am not served with the notice when the matter, this matter is disposed of. Even though my learned friend.
List MFA number?
2963 of 2022.
2963 of 22. Call this matter.
Monday.
You'll see, you'll consider your appeal.
Yes,
If at all there is going to be any modification, then this would arise.
Yes, my
recall.
lordship.
If I'm going to not appreciate,
Because there was no DL in that.
I will hear you. If I'm not going to appreciate that, where's the question of recalling this?
Yes,
If there is going to be any interference by
Yes,
this court, then certainly that could be considered for recalling.
Much.
If you satisfy this court. So we'll call that matter along with.
Yes.
You serve a copy on Mr. Shastri.
ಅಲ್ಲ ನನಗೆ ವಾಟ್ಸಪ್ ಕಳಿಸಿದ್ದಾರೆ.
ಕಳ್ಸಿದೀನಿ ಸುಮ್ಮ ಅವತ್ತೇ ಕಳ್ಸಿದೀನಿ.
WhatsApp
Mr.
ಆದ್ರೆ
Shastri.
yes, I received through WhatsApp and just I taken out printout. But the thing is, when this matter is called, my lord, I am not served with the notice. So I have no opportunity to bring it to your lordship. My learned friend filed an affidavit stating that both of us are not brought to the notice. That is hurted me. That is
Now
hurted me.
you go through that and submit next.
Yes.
When do you want, next Monday?
Ah, yeah.
Any date, my lordship? All right.
Bill number 19, Sanat Kumar KM.
Call on fifth, madam.
Claim petition dismissed, Miller.
Huh?
Claim petition dismissed, Miller. LCR to be called.
Dismissed,
Please.
Ravish.
Delay may be condoned.
Now 1 of 21 allowed, delay of 47 days is condoned. Is this matter for admission on?
Please. Date.
22nd.
Must have.
Bill number 20, Sushmita Ji.
Yes.
We have served the copy, my lord.
My lord, I have not received the copy. I have not received.
P. Vijay Kumar.
1 of,
correspondent.
1
I have
of
not
22
received the
allowed,
copy.
delay of 11 days is condoned. Call on.
22nd.
Yes, much obliged.
Direct the appellant to furnish the copy.
21,
ಕೊಟ್ಟಿಲ್ವಮ್ಮ madam? You have not given copy? ಕೊಟ್ಟಿದ್ದೀರಾ? She is given ಅಂತಾರಲ್ರಿ Mr. Vijay Kumar.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಕೊಟ್ಟಿದ್ರು ಸರ್ ನಾನು ತಗೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕಪ್ಪ
So one more
ಎಲ್ಲ
second.
12/7 ಎಲ್ಲ ಮೊನ್ನೆ ಆರ್ಡರ್ ಆಗಿದ್ದು ಅವ್ರು ಕೊಟ್ಟೇ ಇಲ್ಲ.
All. Jagdish,
Yeah, may please. The claimant's appeal dismissed.
IE 1 of 23 is allowed, delay of 98 days is condoned.
Second respondent Cholamandala, ಅದು ತೋರ್ಸಿಲ್ಲ ಕಾಸ್ಟ್ ರೇಟ್.
Second respondent ಇದ್ದಾರಾ?
ಹೌದು ಇದಾರೆ.
Yes, Mr. I am for the first respondent.
R2 ಇದ್ದಾರಾ?
Cholamandala MS General Insurance Company.
Yes. ಇದರಲ್ಲಿ ಸೋಲಪಂಡಲಿ. RHS. Learned Counsel Sri HS Lingaraju.
Sir.
Directed to take notice for respondent number 2, registry to show his name in the cost list. List on.
23rd. Serial number 22, Chetan B.
My lord, it's a owner's appeal, my lord. We have challenged the, my lord, the relationship of employer and the employee. My lord, I would request this honorable court, my lord, to consider this matter at the time of final hearing, my lord. If the amount is withdrawn, my lord, nothing will survive for consideration.
My lordship, the appellant has admitted the employee and employer relationship, my lordship.
Is denied ಅಂತಾರೆ ನೀವು admit ಅಂತ.
ಅಲ್ಲ admit ಆಗಿರೋದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಸ್ವಾಮಿ.
Both the counts, get ready to argue. List this matter for admission.
Kindly have it on Monday, my lordship.
On which day the application for stay would also be, withdrawal would also be or the IA 5 of 24 would be considered along with the main matter list for admission. Call on 22nd.
Please.
Obliged,
Bill number 23, Sumana SN.
Sumana. IA 1 of 24 is allowed, delay of 100 days in filing the appeal is condoned. Notice ಹೋಗ್ಬೇಕು ನಮ್ಗೆ first matter. Service ಇಲ್ಲ.
First time. Check mark.
Madam, let's strike off issue notice to respondents on main and IA.
First time.
Yes, Mr. Shastri.
It's done 28.
Huh?
28 is the date.
20.
Serial number 24,
My lord, I am for a claimant's appeal for enhancement
Issue
notice.
notice.
serial number 25.
Same
date,
issue notice.
Serial number 26,
Same issue notice.
27,
27, Shivana Gowda.
Appearing for respondent, my lords. We have filed the IA number 2 of 2024, my lords, for release of the amount that is deposit, 50% amount, my lords. My lord,
Yes, what are you challenging?
Quantum only.
Quantum, release ಮಾಡಬಹುದಲ್ಲ?
50% ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ, ಔಟ್ ಆಫ್ ವಿಚ್ ಮೇಲೆ 50% ಮೇ ಬಿ.
ಯಾಕೆ?
ಅಷ್ಟೇ ಬರೋದು.
ಅದಕ್ಕಿಂತ ಕಡಿಮೆ ಆಗುತ್ತಾ?
ಹೌದು. ಅದಕ್ಕೆ. ಮಿಕ್ಕಿದ ಅಮೌಂಟ್ ಇಲ್ಲೇ ಇರುತ್ತೆ ಸ್ವಾಮಿ, ಅವರೇ ತಗೋತಾರೆ. ಮಲಡ್ ಇದ್ರಲ್ಲಿ ಕ್ವಶನ್ ಆಫ್ ಮಲಡ್ ಈಸ್ ಕಂಟಿನ್ಯೂಯಿಂಗ್ ದಿ ಸರ್ವಿಸ್. ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ ದೇ ಆರ್ ನಾಟ್ ಎಂಟೈರ್ಡ್ ಟು ಗೆಟ್. Therefore, my lord,
14 lakhs 21. So you have deposited 7 lakhs and odd.
Please.
yes.
Permit him to.
ಅದೊಂದು 5 ಲಕ್ಷ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ.
50%, my lords, because, my lords, the PWT, the doctor itself, he's told that it would cost about 3 to 3.5 lakhs, 4 lakhs amount. Then future medical expenses and all of that. So if-
stay ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ.
50% deposit advance stay.
We have deposited the amount.
Heard learned counsel for the appellant and counsel for respondent. IA 2 of 24
Yes, my lords.
is filed by learned counsel for the respondent number 1. Seeking for withdrawal, permission for withdrawal of the amount deposited by the appellant insurance company. Peruse the affidavit annexed to the application, being satisfied with the same and the need for the amount for the present. This court deems it appropriate to permit the respondent number 1 to withdraw 5 lakhs out of the amount deposited by the appellant. Full stop. ಎಲ್ ಮಾಡಿದ್ದೀರಾ?
Before MSC.
Tribunal.
Before MSC. Tribunal.
The tribunal is hereby directed to release and disburse rupees 5 lakhs out of the amount deposited by the appellant to the respondent number 1 bar claimant by way of electronic transfer upon the respondent number 1 furnishing relevant bank details.
My lords, we have filed an MFA COB also, my lords. That may be clubbed with this. FR number 47 of 2024.
No FR number, you give the
FA
MFA.
number.
My lords, a copy also has not been served in this matter.
Good, what copy?
The MFA copy, my lords.
ಕೊಡ್ತಾರೆ ನಿಮ್ಮ appeal copy.
Aviator.
Do you have that MFA CROB number?
FR number stays, my lords.
All right, if you get, you give,
You sure?
so we will call it
Much
on, call on next date you.
Much obliged. my lords.
Seal number 28, Girish B. Baldare.
Should notice,
30th August. Seal number 29,
notice,
30,
same.
Milords,
ಇದೆಯಲ್ಲ, Sitaram Rao.
number 30.
Milords, I appear for the appellant in the matter. Case of injury, Milords, misrepresented claim petition. The insured himself files a claim petition by misrepresenting facts without noticing the same, Milords, there is an award.
Third council issue notice to respondents on main and IA. Pending consideration of IA 1 of 24, IA 2 is taken up by imposing certain conditions. There shall be stay of operation and execution of the interim judgment and award dated 9/8/23 in MVC 534 of 22, passed by Senior Civil Judge MACT Belur Hassan, subject to the condition appellant deposits 50% of the award amount before the tribunal
court,
within
Milords.
4 weeks from today.
Before this court, Milords,
Before, you want this court?
please, Milords.
For this court within 4 weeks from today.
Released on 30th August. Seal number 31,
That-
Nagaraj K.
31 IFA for the appellant KSRTC. Milord, stay may kindly be granted subject to the deposit of 50% of the award amount.
Counsel for the
R2 is the driver of the
appellant,
KSRTC.
notice for
Notice
respondent
may kindly be dispensed.
pending consideration of IA 1 for delay. IA 2 is taken up for consideration by imposing conditions. There shall be stay of operation execution of the judgment award dated 12/9/23 in MVC 488 of 20, passed by Additional Senior Civil Judge JMFC MACTs at Sagar. Subject to the condition, the appellant corporation deposits 50% of the award amount before the tribunal
Before the tribunal, Milord.
within 4 weeks from today.
Notice to R2 may kindly be dispensed.
Notice to,
R2 is the driver of KSRTC.
notice to R2 is dispensed at the risk of appellant.
Released on 30th August. Seal
Please,
number
ma'am.
32, Girish B. Baldare.
Appear for appellant. Kindly issue the notice to R1, my lord.
Claimant,
Yes, my lord.
issue notice.
And R2 is a dispensation.
Yara,
R2,
notice to, file a memo, where's the memo?
a file a counter.
Huh?
File the memo in counter.
All right, notice to R2 is dispensed, memo accepted.
It's on 30th August. Seal number 33, Many Ravish.
Liability, please, DL. Appeal is barred by limitation, 22 days.
to third level counsel for the appellant issue notice to respondents on main and IA. Pending consideration, delay,
Delays, 22 days
Decision of IA. 2 of 24, IA 1 is taken up by imposing conditions. Shall be stay of operation execution of the judgment and award dated 4/3/24
Criminal plea.
in MVC 249 of 19. Asked by additional judge, district judge, additional MSCT at Udupi, sitting at Kundapura. Subject to the condition, the appellant deposits 50% of the award amount before the
Criminal plea.
jurisdictional tribunal within 4 weeks from today. Next,
Connected plea.
same,
So arising the same accident, different petition.
all right, madam, in this also same order,
MUC number.
the number will change. MVC, order dated 4/3/24, MVC 248, same court, 50%.
Please.
8th August. Admission matters, serial number 35 adjourned, 36, Gurudev Prasad KT.
I am for respond number 2, my lord.
Case of injuries.
Ready, both of you?
Ready, my lord.
There was a software engineer getting salary of rupees 1,23,550. And he resigned the job. Even according to the doctor PW3, he is suffering with 33.63% to the limb. And whole body 11.21%.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Comminuted fracture of left radius. Page para 15A, para 15A. Comminuted fracture of left radius, and he was treated at Sakra Hospital for as an inpatient for 3 days. He was operated with plating and K-wire inserted.
What is the disability?
30, PW3 doctor, 33.63% to the limb. That has not been discussed in the judgment. 33 court, simply court has taken at page 18, court has said to a 6% disability. That is not correct.
All right, where is the evidence of doctor, what he says?
Doctor says 33.63% to the limb and 11.21% to the whole body.
Which limb?
Left upper limb, left hand.
And the whole body, he says?
11.21.
11.21.
Yes.
Why the tribunal takes 6%?
Simply says he might have suffered 6%.
Yes, what else?
And of course, no amount has been granted for loss of future prospects.
What is the age? What is the income?
31 years.
Income,
Rupees 1,23,550.
ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿಲ್ಲ, ಅದೇನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
What is the document you have produced?
In fact, in PW1 in his evidence, he stated that
Admitted, yeah, I am the.
he resigned the job, and for about 7 months, he had no job. At least for the 7 months, the court could have considered. He says that he is getting same salary after 7 months. Or during those period, at least some amount would have been granted. After resignation as per exhibit P8 and 9, to get a job in some other company, at least 7 months, that is the evidence.
Yes, you are admitting all this?
No, my lord, so because he getting after accident also he getting 1 lakh before accident, my lord, 1 lakh 23,000 rupees has been getting clear, my lordship. After accident, 1,63,112 rupees has been getting salary. But they have not produced any document to leave certificate or the bank statement, everything to not produce, given salary.
Salary certificate is produced.
They have produced salary certificate, but remaining 7 months, they have not produced bank details, my lordship, whether the amount has been, salary has been credited or whatnot.
All right.
That purpose only, learned, MACT has been, came to para number, can I permit it to read, my lordship? Para judgment page number 16, my lordship. Below 6th line, my lordship, evidence of that petitioner himself resigned the job and his salary hiked. He has received this salary from the month of January without any deduction. As per the exhibit P8, resigning his job the month of March. So far, accident used to get the same salary, continuing the same profession in the settled position of law. That while granting the compensation under the head of the future loss of
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
judgment para number 17, judgment page number 17, my lords.
ಎಲ್ಲಿ? Page number 17, where are you reading?
First page, first line, my lords.
Read it.
That while granting the compensation under the head of future loss of earning, there must be evidence to show that the result of injury in the income was reduced or reduced or there was loss of earning or is removed from the service. Account of disability, he is incapable of doing any work. Looking to the factual and documentary evidence on record, the petitioner not at all suffered for any reason as stated supra. Hence, the absence of these facts, the question of the awarding the compensation under the head of loss of future earning will not arise at all. Looking the avocation of the petitioner, there is no functional disability which restricted discharge as his duty to looking to the salary certificate, which is clearly shows that his efficiency in the work, the good satisfactory, and hence the getting more than earlier to the accident in the new working place.
What is the material to show he is getting more?
He has admitted in the evidence that same salary he is getting in the cross examination of PW1.
So you continue.
I am not
Continuing.
asking for loss of future earning. For the gap between when he resigned the job, for about 6 months, he could not go to the other company to secure the job. For those period, at least for that period, he is entitled for some compensation.
What is the material you have placed to show that you did not work during this period?
Only the oral statement, even in the cross examination also.
How will you substantiate it?
Yeah, he resigned the job immediately after 1 month of the
All
accident.
right, you resigned, fine, but where have you said, where have you produced any material to show?
No documentary evidence.
You should have produced your bank statement.
That also not.
That there was no income coming into your account.
Yes,
Onus is on you.
but this bank statement of exhibit P9 is produced. But that doesn't.
May not be for the period of your resignation and joining the new job.
That is the gap period. That is my submission. And for loss of amenities, only 10,000 is awarded. And medical expenses, he got
What is the
reimbursed.
injury? What are the injuries that is suffered?
Comminuted fracture of left radius. What the doctor says is PW3
Comminuted fracture of left radius.
radius,
And what is the job you were doing?
like a software engineer. Both the hands are hyalinous. X-ray right wrist shows plate and screws in C2 with osteoarthritic changes in the left wrist joint with the displacement of left styloid process of ulna. And disability has been calculated in detail. So these are the disabilities.
He's taken treatment period, my lord, 25 to 25.
So what about the amount that you have spent for medical expenses? Is
That has been
reimbursed?
reimbursed by the insurance company, 3 lakhs.
3,50,000 towards medical expenses, learned counsel for the petitioner.
The pain and suffering, 50. 50,000, attendant charge, nourishment charges 50,000,
Medical expenses not given.
amenities and happiness 10,000.
Loss of amenities and loss of income during that gap period at least.
That you have not placed any material. Yes, that's all.
That's
Record. Have you stated in your evidence when you resigned and when you took up the next job?
Yes, and for 7 months, that's what is I have stated in the, just I read.
And what was your salary per month?
Per month, 1,23,550. That salary certificate also produced.
1 lakh?
1,23,550. 550.
So this amount can be awarded.
Well, they have not produced any document after accident period of 7 months, whether the company has been salary has been credited or.
Or did you cross-examine him?
not.
Read the evidence, cross-examination.
You are not done. No.
I read the. At the time of accident, this is cross-examination. At the time of accident, I was working as engineer earning rupees 1,23,550. I have received the entire salary for the month of December 2018 and January 2019. As per Exhibit P8, myself resigned the job. The witness volunteer stated that I am unable to do work, I resigned it. Now I am getting gross salary of rupees 1,63,112 from Essential Software Company. That is the another company. It is false to suggest that as per the bank statement, the entire follow-up treatment amount has been reimbursed. Exhibit P10 driving license is not surrendered to her. It is false to suggest that I have stated not attended 7 months for job is false. I am income tax assessing. I have no independent impediment to produce income tax details. It is false to suggest that action took place. The
Bank
other things.
statement kotidirella, exhibit
ಕೊಟ್ಟಿದೆ.
P9. That is showing for which month?
That is for the from January 2019
to
to 479. Twenty-two 9/19. Sorry, 110/19 up to 110/19. ಅದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಅಮೌಂಟ್ ಎಲ್ಲ ತೋರಿಸಿದ್ದಾರೆ ಬಂದಿರೋದು. ಸ್ಯಾಲ್ರಿ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಸ್ಯಾಲ್ರಿ ರಿಸೀವ್ಡ್ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. 110/19. All expenses.
That is exhibit P9 ಅಲ್ಲ ಅದು?
P9.
What is the cross-examination on that?
ಅದ್ರ ಮೇಲೆ ಏನು ಮಾಡಿಲ್ಲ.
How many months? 7 months.
7 months.
Already you see that and tell now.
Please, madam, I will check it, madam.
ಅದು ಕೊಡ್ರಿ ಅವ್ರಿಗೆ, let him see it. Bank statement ಇದೆಯಲ್ಲ?
Please, madam.
December accident ಆಗಿರೋದು.
ಹೌದು.
So after that you see whether he has received any amount more than 1 lakh rupees as salary.
For January, he received the salary.
January, you must have got the salary of December. So you should have got from thereafter for 7 months. If you are not received, then you will be entitled.
Please, madam, I will check it. Kindly pass over, madam, I will check it.
Next.
Seal number 37, Vinod Gowda.
Respondent, my lord, today I received the copy. It may be referred to local, my lord. But the corrected case is settled, therefore it may be referred to local.
Both the learned counsels for the appellant and respondent submit the matter be referred to Lok Adalat as to resolve amicably. Hence matter is referred to Lok Adalat.
Seal number 38,
To the LCR and I'll make submission now this next week.
Learned counsel for appellant seeks time, call on.
9th August.
Please.
Seal number 39, Arjun, 40.
Ninth, maybe I will, eighth,
The 8ನೇ ತಾರೀಕು.
please,
Call on 8.
please.
Lord, this matter records is required because 20% of contributory negligence was,
ಇದೆಯಾ? ಇದೆಯಲ್ಲ?
yes, ready.
40 ಅಲ್ಲಿ ಇದೆಯಾ?
40 ಅಲ್ಲ.
You are appearing in serial number?
40.
40.
40 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? 40 ಅಲ್ಲಿ Nagaraji,
Yes.
records are required.
20% contributory.
Only quantum
negligence the contributory negligence was fixed against the claimant, my lord, 20%.
My lord, two vehicle involved accident, motorcycle and car. IME report clearly says two vehicle damage. 20% and 80% is correct.
FIR?
Against car driver, one.
Huh?
Against the car driver.
Car driver,
secure
cast it against the car.
Register to secure records, call on, released on.
Yes.
21st August.
Giri Mallayya.
Number 41, Girimalaya.
The respondent corporation may not. One matter.
Time for respond number 1, my lordship. Matter may be posted on Monday, my lordship. I want to get some records, my lordship. Contributory negligence fixed against to the insurance company as well as the KSRTC, my lordship.
ಇಲ್ರಿ ಅವ್ರು ಬಂದಿದ್ದಾರೆ ಇವತ್ತು ಫಿಸಿಕಲಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು VCL ಇರೋದು.
Sorry, my lord, sir.
File ಸ್ವಲ್ಪ ನೋಡ್ಬೇಕಿದೆ ಫೈಲ್. Entire records. Contributory negligence has been fixed against to insurance.
Right, what is this note in your matter, Mr. Karthikeyan?
PF has to be paid, my lord, but PF has been paid, my lord.
Notice to R3. Who's R3? R3 ಯಾರು ನಿಮ್ ಕೇಸ್? R2 ನಾ? So ಅದರಲ್ಲೂ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ. Who's R3?
Owner of the vehicle.
Owner of the vehicle, my lord.
Owner.
Yes.
You are appearing for whom?
Appellant ಮೇಲೆ.
Case artist. ನೀವ್ ಯಾರಿಗೆ?
Appellant claimants ಮೇಲೆ.
Claimant. Liability is fastened on you only, na?
Both,
Are you shifting the liability?
Yes. Contributory negligence we wanted to be.
No, you want to shift it to the owner or to this vehicle?
Vehicle.
Not to the owner. And where is the requirement?
My lord, since they were a party in the trial court, my lord, sir.
No, if you are not seeking any relief, you might as well dispense, because in the first matter it is dispensed.
Please, my lord.
I'll file a bill.
Yes, but that's up to you.
Please, I'll file a bill.
Shall I take it? All
Or
right.
my lord, on Monday,
All right, I'll list it on Monday, you verify.
I shall.
Learned counsel for the insurance company seeks time. Call this matter on 6th,
Please, my lord.
Tuesday.
Please, my lord.
42, Kumara KG. G. Vijay Kumar.
Case of injury. Case of
Respondent.
Yeah, ready?
Ready. Only in two heads, my lord. The notional income has been taken 9,000, 2017.
ಮೈಕಲ್ ಮಾತಾಡಿ, ನೀವು ಮೈಕ್ ಕೊಟ್ಟಿರೋದು ನಿಮ್ಗೋಸ್ಕರನೇ.
Please, my lords.
ಅವ್ರು ಕೇಳ್ಬೇಕಲ್ಲ ನೀವ್ ಹೇಳೋದು.
My lords. The disability, my lords, doctor assessed 24%. And my lords, the income, the 2017 accident, my lords, income has been taken, notional income 9,000. My lords, that has to
Accident
be
ಯಾವಾಗ?
2017,
17
please.
My lord, there is a total mistake in the judgment
Are you sure?
and all, even in the synopsis also. ಒಂದ್ ಕಡೆ 17 ಹೇಳ್ತಾರೆ, 2077 ಅಂತ ಹೇಳ್ತಾರೆ, 2007 ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾವಾಗ ಆಗಿರೋದು ಆಕ್ಸಿಡೆಂಟ್?
2017, my lords.
ಮತ್ತೆ 7 ಅಂತ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ ಜಜ್ಮೆಂಟಲ್ 17 ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
Judgmental 7 ಅಂತಿದೆ. You have also said 7 in your appeal.
7 and also 2017 ಕೂಡ ಹೇಳ್ತಾರೆ.
ಕ್ರೈಮ್ ನಂಬರ್ 2017 ಮೆಲೋಡ್ಸ್.
Huh?
ಇನ್ ಪ್ಯಾರಾ ನಂಬರ್ ಪೇಜ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ ಅದು 7 ಅನ್ನೋದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
Page number?
16 in page number 7 crime number 49 of 2017 ಯಶವಂತಪುರ ಟ್ರಾಫಿಕ್ ಪೊಲೀಸ್.
Crime number.
Issue number
Forget
1
about the crime number, I say. When did you file the, when did the accident happen?
2017 my lords.
Why you have said then 2007 in your appeal?
ಆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆತರ ಬಂದ್ಬಿಟ್ಟಿದೆ.
So ಅದಕ್ಕೆ ನೀವು ಅದನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ? So continue with the perpetual mistake and error committed and further create more confusion.
My lord, and one more thing, my lord, in the synopsis, page number 2, you last kindly see, they have also mentioned another certified copy of MVC 7375/17. And also MVC 4180/21. ಅದೇನಕ್ಕೆ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ಎಲ್ಲೂ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ.
I'll look into it my lords. I'll make submission.
Counsel for appellant to verify and make
Meanwhile, my
proper
lords, record-
corrections with regard to the date of occurrence of accident in his appeal memo.
Records may be called.
Or not. ಏನ್ ರೆಕಾರ್ಡ್ಸ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ?
ಅದರಲ್ಲೇ ಕ್ರೈಮ್ ನಂಬರ್ ಅದರಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ my lords because ನಾವು ರೆಕಾರ್ಡ್ಸ್
ಅಲ್ಲ, it is my lord, correct my lord, 2017 we can take it as a date of accident. But one thing I want to know, he has referred to another MEC 4180/21. Page number 2 after the tabular form. I don't know why he has produced and no explanation is found in any places.
ಇಲ್ಲ ಅದು by
ಅವ್ರಿಗೆ ಗೊತ್ತಾದ್ಮೇಲೆ ನಿಮಗೆ ಹೇಳ್ತಾರೆ, ನಮಗೂ ಆಮೇಲೆ ನೀವು ಇಬ್ರು ಹೇಳಿ.
ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಇನ್ನ.
Alright, call on.
19th August.
Monday my lord. Monday.
Monday ಹೇಳ್ತೀರೇನ್ರಿ ಮಿಸ್ಟರ್?
please Monday ಬೇಡ Tuesday.
Released on Wednesday. Take your
Please,
time.
madam.
7th August. Cell number 43. Syed Abdul Sabur. Jwala Kumar Farrar to.
Lord, you have done next Wednesday or Thursday.
There are counsel for R2C.
7th.
List on 7th.
I think liability ಇದೆ, ಅದನ್ನ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ಹೇಳಿ, I will report.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ?
ಈಗ just now I look into the judgment.
7th.
7th. Cell number 44. Girimalaya. Second party for respondent. G. Jairaj Farrar to.
Ready?
ನಾನು ರೆಡಿ.
ಅಶೋಕ್ ಪಾಟೀಲ್ ಬರ್ಬೇಕಲ್ಲ? ಪಾಸ್ ಓವರ್ ಮಾಡುವ?
ಮಂಡೇ ಪೋಸ್ಟ್ ಮಾಡ್ಬೋದು.
Alright, I'd request to relist this matter on Monday, 5th August.
Cell number 45.
Sadashivaya.
KG.
Appellant in this matter, my lords. My lords, in this case, my lord, the legal heirs of the deceased, my lords, have filed an appeal questioning the validity of the order passed, wherein, my lords, the injured person has also filed another appeal in MFA 6286 of 22 that is still pending for admissions, my lords.
Whose appeal is this?
This appeal is filed by the deceased, my lord. The offending vehicle,
LRs,
LRs, my lords, the LRs of the
which is other appeal is filed?
The
by-
other appeal is in MFA 6286 of 22 that is filed by the injured seeking enhancement, my lords.
How many of them were traveling?
Motorcycle, my lord. The offending vehicle, the rider of the offending vehicle is no more deceased. His legal heirs have been made as party. The injured has filed another appeal seeking for enhancement of the compensation awarded.
So you are appearing for the claimant?
Not the claimant, my lord. I'm the offending vehicle's legal heirs, my lord. The owner of the offending vehicle is no more deceased. His legal heirs were made as a party. And my lord, the court has
The
granted,
respondent appeal.
please.
Respondent, you are the owner of the offending vehicle.
Please, ma'am.
So he's no more.
He is no more. The legal heirs, wife and daughters have been made as party.
All right.
And I have preferred this appeal questioning the validity of the Order passed by the court.
Which is that other case number?
MFA 6286 of 22.
Call MFA 6283 of
86 of 22.
86 of 22
Two, my lord.
along with this appeal. Call on.
12th August.
Great.
Seal number 46, Rangegoda NR. Dada BP for respondents.
They are challenging quantum, my lord, regarding the age of the deceased is disputing.
Corporation.
Please.
Where is Radha?
The BP for respondents.
You are ready, madam?
Sorry, I'm a little late.
Hmm?
Pass it on.
Pass over. Pass over, please.
Seal number 47, Nayak Krishna Venkatraman.
Appeal for appellant, my lord. Claimant's appeal for enhancement.
This also you want pass over?
Please.
Pass over.
48, Sridhar DS.
Appellant's counsel. Case of amputation of toes, my lord, he was aged about 13 years. 3 toes, this one.
Minor boy, my lord, aged about 12 years.
First, second and third toe.
Toes of right foot.
Right toe, right foot, 3 toes removed, my lord, amputation because of the accident he suffered. Trial court has granted 1,57,000 and medical expenses 7,000, 50,000 towards hospitalization charges and 1 lakh towards disability. My lord.
So my lord, conveyance and this one attendance charge is not given. And amenities also not granted, my lord, and future loss of income also not granted.
Records idea.
Ill-
It to be called.
You have the photographs?
No way. No.
How do you come and argue then? Exhibit P10 illa anmele. And you want this court to pass an order when you are yourself not equipped.
I thought amputation is means
But how to see? He's a young boy of 13 years.
call for record.
12 years.
Something at least you should see to believe what you're saying. Of course, there is some amputation. How is his condition after the amputation? So you're now asking for future prospects,
Yes, ma'am.
earning capacity. What is the law on that minor injury of this
Well, if there is
amputation
no-
of toes?
Toes, not 10% has been stated by the doctor.
Correct.
He was aged about 12 years.
Now, what is the income to be taken?
When if you take more 30,000 notional income as per the Kishan Gopal case,
Ah.
it comes more, he has
That
calculated
Kishan Gopal's case is for injury or death case,
that income, notional income of the minor children,
30,000
30,000.
per annum.
They have calculate ಮಾಡಿರುತ್ತೆ. It comes more 10% is taken
I'll check up this aspect and I'll.
What would be the multiplier?
because less than as per Sarada Varma case was, my lord, there is no multiplier, but as per second settlement up to 15 years, 15 multiplier.
15. As
As
per
per second settlement,
second schedule.
second schedule.
So 30,000 into 15. Into 10%.
45,000 ಏನೋ ಬರುತ್ತೆ. 10%.
Kindly take it as a matter next week, my lord. Meantime, call for the records. I'll check up the regarding future prospects judgment.
Global compensation can be awarded.
Yes, ma'am.
I am told that the judgment is there in the point. I'll check up and.
Counsel for appellant seeks time. Released on. Your records illa alla idralli?
TCR may be called.
Check your records. Released on.
Twenty-first, sir.
Watch it.
Still number 49 adjourn, 50. Right, Kumar,
In this case of death. The
Matter
honorable
may have it
tribunal
as-
not consider dependency and also consortium. And the ground
Tomorrow.
that they are the sisters and brothers of the.
ಹೇಳ್ರಿ ಅವ್ರು ಏನೋ ಹೇಳ್ತಾರೆ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್
Matter
ಶುರು
may-
ಮಾಡ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
Matter may be have it on Monday. Since ಮೇಲೆ ಶಿವಣ್ಣೇಗೌಡ ಅಂತ ಅಷ್ಟೇ BC ಅಂತಿಲ್ಲ ಹಂಗಾಗಿ ನಾನು ಫೈಲ್ ತರ್ಲಿಲ್ಲ. ಇವಾಗ ಗೊತ್ತಾಯ್ತು ನನ್ಗೆ. If it is only for the enhancement, if the
enhancement.
liability is not challenged, I have no objection, but otherwise I have to see that.
Not liability is not challenged, they are only enhancement, dependency is not considered on the basis that they are
That's the
married.
reason.
and the sisters
Then
and
it is
brothers. That is
necessary.
there, that is the case.
I will argue the matter on Monday, my lord.
All right, the counsel
Monday,
for
ma'am.
respondent number
Please,
2 seeks time. List this matter on
Monday.
Monday, 5th. Registry to show the name of counsel
B-
for
B-
R2 as BC Shivannegowda.
Please.
Still number 51, Sanat Kumar, KM.
Claimants for appeal for enhancement, my lord. Case of injury, my lord. Is the farmer, my lord.
Farmer.
Farmer.
Hmm.
The offending vehicle dash against the bullock cart which has been right by the appellant, my lord. in which he sustained injuries and he lost the control of entire his left leg, left arm only. The doctor has assessed the disability at 79.32 for functional disability.
What is the age?
Age is 41 years, my lord. The tribunal has considered 50% to the whole body, my lord, as a functional disability instead of 79%. It has
So chronological argument, madam.
please.
What is the age? What is the date? What is the multiplier? What is the
Multiplier
allocation?
14,
What is the income taken?
8,000 per month, my lord.
What should have been taken?
11,000.
ಅದೆಲ್ಲ ಹೇಳದ್ ಬೇಡ ಸ್ಟೇಟ್ ರೆವೆನ್ಯೂ PW2
Next
ಡಾಕ್ಟರ್ ಬಿಟ್ರೆ
next ಇದಕ್ಕೆ ಹೇಳೋಣ.
chronologically you should learn as a lawyer how to begin.
Sorry.
Chronologically you should argue. I should be able to understand. Do I know the case? I don't read your papers and come.
Sorry.
MVC at least. 17 ಎಷ್ಟು ಬರ್ಬೇಕು 11,000.
11,000.
Yes. Now you come to the evidence of doctor and disability.
Crush injury, my lord. Crush injury of left hand.
Paragraph ಹೇಳ್ಬೇಕು.
Para 23.
31.
ಇದನ್ನ ಕಲ್ತ್ಕೊಳ್ಬೇಕು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ನಿಮಗೆ.
Sorry.
Otherwise I can see the papers myself and dictate. There is no difficulty for me. When you will learn. Para ಏನು?
Para 23, para 23 ಅಲ್ಲಿ distal 1/3 crush injury to left hand.
ಅವ್ರು ಹೇಳಿ ಇರಿ.
Please.
Yes, yes, ಮಿಸ್ಟರ್. ಹೇಳಿ ಸರ್. Forearm soft tissue loss, distal forearm extensor compartment, metacarpal measuring 15 into 10. Degloving of skin, distal forearm till proximal phalanges. Partial loss of little finger.
The middle and distal phalanges and the tenderness along with the absence of wrist joint movements for which he had undergo surgeries for thrice as aforesaid. Therefore, having regard to the said nature of injuries, he suffered one of the on the part of organ stated above and having regard to the fact that he was an inpatient nearly for 25 days in the aforesaid mentioned hospitals. It is seen that the petitioner has not only sustained crush injury on his left hand, he had lost his tooth injuries on his head, face, chest, right knee, etc. Under these circumstances, it is but natural to infer that the petitioner must have suffered pain, agony, discomfort, and also inconvenience. Therefore, pain and sufferings needs by the petitioner has to be suitably compensated under the said dates. Therefore, it is just and proper to award a sum of rupees 50,000 towards the pain and suffering. As far as the
Disability ilva.
ಇದೆ madam. Para 31, my lord, with regard to disability, para 31, my lord.
30.
31.
Read it.
In this case, the petitioner has reiterated the fact of injuries suffered by him. When he was examined as a PW1, nothing much elicited to disprove the contention of the petitioner. On the other hand, the petitioner has also examined the doctor who has said to have treated him in the Anaga Hospital, Mysore. The said doctor is examined by the court commissioner and he has assessed that after 3 surgeries on the left hand, petitioner is still suffering from pain. There is no movement in the left hand, completely debarred from doing any work in the left hand. There is a scar over the left forearm and hand, including fingers. Accordingly, the doctor has assessed the level of disability as 79.32. That is combined of arm and hand component. Now, whether this assessment of the doctor has to be accepted, it is required to be reappreciated is another question. In order to assess the evidence of the doctor, the parameters are laid down by the Honorable Apex Court in the decision reported in 2011 1 SEC 343.
between Rajkumar and Ajay Kumar, wherein it is held that where a claimant suffers a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earnings would be depend on the effect and impact of such permanent disability as the percentage of economic loss or loss of earning capacity. In most of the cases, the percentage of economic loss, that is the percentage of earning capacity arising from the permanent disability, will different from the percentage of permanent disability. And it is further held as follows. What requires to be assessed by the tribunal is the effect of permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of the percentage of income, it has to be quantified in terms of the money or to arrive at future loss of earning. Keeping these guidelines of the Honorable Apex Court in mind, let us analyze the permanent disability as contained by the petitioner in respect of his loss of earning capacity. As per the medical records, the age of the petitioner as on the date of accident was 41 years. According to the petitioner, he being a rider was getting 1,000 rupees per day out of use of bullock cart for hire purposes, and had an income of rupees 5,000 from the agriculture sources. The doctor has assessed the functional disability of forearm and hand at 79.32. It has to be noted that the movement of forearm and hand is completely restricted and he is unable to do any work from left hand. As such, he being a head of the family, having a burden of maintaining 3 children, a wife and an aged mother, is completely deprived from doing his regular work. Naturally, he cannot earn as much he was earning much prior to the accident. Therefore, considering the gravity of the accident in mind, it would be proper to assess the functional disability of the petitioner at 50% rather than 79.32 as assessed by the doctor. As the income of the petitioner has been already assessed at 8,000 per month, the loss of earning due to functional disability would be 50% of 8,000, which is 4,000. The age of the petitioner at the time of accident was 41 years. Therefore, the multiplier would be 14 as envisaged in the Sarala Verma case. Now, the formula for calculation is as follows. So, 8,000 into 12 into 15 by 100 into 14, 6,72,000. My lord is a farmer, my lord. He lost his left arm completely. Is unable to do any work. He cannot move his rear. Therefore, the functional disability is 100% according to me. The doctor has assessed the 79%. The tribunal has taken 50%. Well, therefore, that is 50% considered by the tribunal is in lesser side, my lord. That has to be reconsidered, my lord. In addition to that, my lord, income has taken 8,000. Please. Further, my lord, he has taken a treatment for about 25 days as an inpatient. So he suffered major injuries, my lord. The tribunal has awarded only 50,000 towards the pain and suffering and 40,000 towards the loss of amenities, madam. In addition to that, only 6,000 has been awarded towards the incidental expenses, though he has taken the treatment as 25 days. In addition to that, my lord, future prospect has to be considered.
Yes.
Therefore, the amount awarded.
Future medical expense here.
Please, my lord.
Future medical expense.
Only 10,000 has been awarded. The doctor, according to doctor, has not specified what future treatment he has required. Therefore, the tribunal has awarded only 10,000. In addition to that, my lord, he is claiming that petitioner, the appellant has claimed damages to his bullock cart and cows, my lord. That has been awarded. 95,000 has been awarded towards that, my lord. He has filed both 2 MECs, my lord. By clubbing both, he has awarded common judgment, my lord. Damages to the bullock cart and cows, my lord.
95,000.
95,000 has been, that has not been challenged, my lord. That has been accepted by the appellant, my lord.
Yes.
My lord, the doctor assessed, my lord, the particle
limb, my lord, 79.32% to the regarding arm. As per the EC Act, my lord, so far as the arm is concerned, my lord, 50% is there on functional disability. Therefore, my lord, the MSCT has rightly considered 50% as functional disability. 41-year-old, my lord, 25% future prospects may be added, my lord, on that 50%. And pain and suffering, my lord, 50,000, according me also, it is a lesser side, my lordship may interfere on that. And food nourishment attendance charges, 6,000, that is also lesser side. Lordship may consider 11,000 income, lord, laid up paid also, 24,000 has been granted 4 months, that may be increased.
So only the forearm.
Forearm, my lord.
The entire left arm, I mean.
All right. Yes,
Entire left arm has been.
correct. So he
ineffective.
has agreed for that 50% plus future prospects.
According to my lord,
As per the schedule,
no, I'll say in schedule, my lord, schedule serial number 4, my lord, in arm component.
now how it can be taken as 100%?
No, my lord, yeah, at least 60% it has stated in loss of hand or thumb and 4 fingers of one hand or amputation from. So at least thumb and 4 fingers has been, for the thumb and 4 fingers, it has to be considered 60%. Yes, last, the entire arm, my lord,
All right.
at least 60% has to be taken.
All. Yes, per code. That's all.
Please.
Write down. This appeal is preferred by the appellant claimant challenging the judgment and award of dated 25/7/2019 in MVC 1453 of 2017 on the file of Principal Senior Civil Judge and MECT Mandya. The appeal is founded on the premise of inadequate compensation awarded by the tribunal. Full stop para. Parties shall be referred to as per the status. Please sit down. As per the status before the tribunal. The tribunal has awarded total compensation of rupees 10,70,000,004 rupees.
Out of that, my lord, which includes 95,000 towards the damages, my lord.
It's okay,
Otherwise, it is 9,75,000,
including
95,000 damages.
including rupees 95,000 as damages in the other connected matter in MVC number 687 of 2018. Along with 6% interest per annum, and directed the respondent number 2 insurance company to pay the compensation, to deposit the compensation within 30 days. Full stop. It is the vehement contention of learned counsel for the claimant that the tribunal has committed a gross error in not awarding suitable compensation and as misdirected itself in not taking into account the permanent physical disability of the left hand forearm, left forearm, which is absolutely non-functional, and the claimant, being a farmer by an agriculturist by profession, would be unable to do his work in view of the crush injury suffered to the left forearm. It is further contended by learned counsel that the tribunal has committed an error in not assessing proper income of the claimant. And so also future prospect ಕೊಟ್ಟಿದಾರಾ ಇಲ್ವಾ? So also the tribunals failed to award future prospects in the matter. It is also contended by learned counsel for the appellant that under other heads, tribunals awarded meager compensation which calls for interference at the hands of this court by way of enhancement. Hence, he is before this court seeking enhancement. Accordingly, he seeks to allow the appeal. Full stop. Per contra, learned counsel representing respondent number 2 insurance company vehemently contends that the tribunal is awarded just and reasonable compensation by taking into account the materials placed on record, both oral and documentary, including the evidence of the doctor PW2, CW2, CW1, na?
CW1.
CW1. Hence, question of enhancement and of income would not arise in the case. The tribunal has rightly assessed the disability, so also has correctly taken the income for awarding compensation. Hence, he seeks dismissal of the appeal. Para. I've heard a learned counsel for the claimant and learned counsel for the insurance company peruse the materials placed on record. Though it is disputed by the learned counsel for the insurance company, the occurrence of accident, involvement of the vehicle, injuries sustained by the claimant have been proved by production of exhibits P1 to P17. The doctor's evidence of CW1 and the records produced by the doctor at C1 to C13 also clearly exhibit the magnitude of the injuries suffered by the claimant. Under the circumstances, the negligence is rightly attributed against the which vehicle? Driver of the Swaraj Mazda mini bus.
Yes, ma'am.
Swaraj Mazda mini bus. Full stop. Para. Now coming to the aspect of age, avocation, income, disability and appropriate multiplier. It is seen that the claimant was aged 41 years as on date of occurrence of accident. The appropriate multiplier would be 14, which is correctly taken by the tribunal, and the same does not call for interference. However, the tribunal has assessed the income to be 8,000 per month, whereas the Legal Services Authority chart for the year 2017 prescribes 11,000 per month. And in view of there being no proof of income, the chart value, chart income has to be taken. Accordingly, 11,000 is taken as the income. We'll stop. Para. Doctor has been examined as CW1, was opined disability to an extent of 79.32% to the whole body. However, the tribunal, on consideration of the evidence of doctor, has arrived at a disability of 50%. Full stop. I'm in agreement with the learned counsel for the claimant that the disability assessed by the tribunal is on the lower side without any proper basis or reasoning to reduce it from 79 to 30.32% to 50%. Full stop. But at the same time, the disability cannot be taken in its entirety as expressed by the doctor. As learned counsel for the insurance company contends that as per the schedule also, the disability for the loss of a forearm is 50%. But in the present case on hand, considering the fact that the claimant is a farmer and involved in agricultural work, his occupation revolves around the use of his both hands, and in view of the serious crush injuries amounting to non-functioning of the entire left hand, he will have to be awarded little more than the value prescribed in the schedule. Accordingly, this court deems it appropriate to award 60% towards functional disability. Full stop. In view of the above disability, the claimant would be entitled to future prospects at the rate of 25%. Therefore, the loss of future earning capacity due to disability would be 11,000 to 12.
25%, 2750,
11,000 plus 20%, 25%.
13 lakhs 86,000.
13,750, na?
Oh, 13,750, 60% of that amount.
13,7, 1 minute. 13,750 into 12 into 14 into 60%. 13 lakhs 86,000 would be 13 lakhs 86,000 as against 6 lakhs 72,000. Full stop. Para. Towards pain and suffering, tribunal is awarded 50,000. This is ಇನ್ನೆಷ್ಟು increase ಮಾಡಬಹುದ್ರಿ pain and
There are 25,000 maybe.
The 25,000 is enhanced under this head. Towards medical expenses, tribunal is awarded 1,73,004 rupees, same is retained. Towards future medical expenses, 10,000 is awarded, same is retained. Towards food, nourishment, attendant charges, 6,000 is awarded. The same would have to be enhanced to 25,000 as the claimant was inpatient for 25 days. Towards loss of income during later period, 24,000 is awarded. In view of this court enhancing the income to 11,000 per month, taking a 4 months period for recuperation, 44,000 is awarded under this head. Towards loss of amenities, 40,000 is awarded. An additional 10,000 is awarded under this head. In all, the claimant would be entitled to total compensation.
17 lakhs 63,004.
Yes, sir.
17 lakhs 63,004.
ಯಾವುದು ಅದು ಆಡ್ ಮಾಡೋಣ 17,63,004.
Please.
17,63,004. Stop. The tribunal has decided the claim petition along with another claim petition filed by the claimant for damages of the bullock cart
and cows.
by awarding rupees 95,000. However, the same is not in challenge before this court. In view of the fact that a common judgment is passed, the said amount of 95,000 is retained. Under the circumstances, adding the said amount which is passed by virtue of a common judgment, the claimant would be entitled to total compensation of
18 lakhs 58,004.
18 lakh
58,004.
18 lakh 58,004. But ಇದರಲ್ಲಿ ನಿಮಗೆ ಎನ್ಹಾನ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಅದರ ಬಿಟ್ಟಾಕ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು. 95,000 ತೆಗೆದಾಕ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು.
Please.
ಅದು ಆಡ್ ಮಾಡಿ ಮತ್ತೆ ನೀವು ಆಡ್ ಮಾಡಿರೋದ್ರಿಂದ ಸೇಮೇ ಬರುತ್ತೆ 7,88,000 ಎನ್ಹಾನ್ಸ್ ಆಗುತ್ತೆ. ಈಗ 95,000 ಮೈನಸ್ ಮಾಡಿದ್ರೆ ಆಸ್ ಅಗೇನೆಸ್ಟ್ 9,75,000 ಅಂತ ಹೇಳ್ತೀವಿ.
ಇಲ್ಲ, ಇವಾಗ ನೀವು ಆಲ್ರೆಡಿ ಯು ಮಸ್ಟ್ ಹ್ಯಾವ್ ಪೇಡ್ ಅಲ್ಲ.
Paid.
So that 95,000 is not going to fetch any future interest.
No, my lord, not.
Because you have already paid.
Paid.
So whatever enhancement is done for the injury case alone will fetch him interest.
Interest 6%.
Please.
So that 1763 minus what you have already paid, he will be entitled for future interest at 6%.
6%. Enhanced compensation.
In view of the above, I pass the following order. Appeal is allowed in part.
Enhanced compensation would be 7,88,004.
Judgment and award is modified. Enhanced compensation.
Enhanced compensation.
7 lakh.
88,004. That would be carries interest.
Judgment is modified. Claimant would be entitled to enhanced compensation of rupees 7,88,004. You agree? Please. Agree. Along with interest at 6% per annum. Enhanced compensation shall be paid or deposited before the tribunal. Tribunal within 4 weeks from the date of receipt of copy of the order, along with the interest at 6%. Can be permitted to withdraw the entire amount.
I have no objection.
Yes.
They want, my lord,
Yes,
they-
actually, that appellant is going to carry out his sister, daughter's marriage. My lord. We want.
The entire amount shall be released and dispersed in favor of the claimant upon proper identification. You want electronic transfer? By way of electronic transfer on the claimant furnishing relevant bank details. Registry to transmit the trial court records forthwith to the jurisdictional tribunal.
Serial number 52.
Yes, yes, in the records. Pradeep has seen the records.
ಬೇಕಾ?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ 38 pass over ಆಯ್ತು. My lord, in that case, my lord, the Liberty General Insurance, I have take notice, my lord. I have collected the documents. Next week, any date, my lord, I will argue that matter. ಅದ್ರಲ್ಲಿ ಒಂದು 2 months ಕೊಡ್ಬೇಕಾಗ್ತದೆ, ನೋಡಿದ್ವಿ.
Which serial number?
52.
36. I think my lord note is mentioning 36.
All right. You want records?
ನಾನು ನೋಡ್ತೀನಿ ಒಂದ್ಸತಿ ನೋಡ್ಬಿಟ್ಟು 2 months ಕೊಡ್ಬೇಕಾಗ್ತದೆ. 1 lakh 2 lakh ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಅಲ್ಲಿ.
ಅದು ನೋಡಿದ್ರ?
ಅದೇ.
ಸಾಫ್ಟ್ವೇರ್ ಇಂಜಿನಿಯರ್.
ನಾನು ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡಿದೆ. ಅವರು 2018 ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. ಮಾರ್ಚ್ 2019 ತನಕ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ಯಾಲರಿ. ಅವ್ರು 19 ಅಲ್ಲಿ ರಿಲೀವ್ ಆಗೋದು. ಆ ಪೀರಿಯಡ್ ಅಂದ್ರೆ ಒಂದು 2 months ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
7 months ಇಲ್ಲ ಅಂತಾರೆ.
ಇಲ್ಲ, ಅವರು ಹೈಯರ್ಗೆ ಜಾಯ್ನ್ ಆಗಿರೋದು. ಅವರು ಹೈಯರ್ ಇನ್ಕಮ್ ಬಂತು.
ರೆಸಿಗ್ನೇಷನ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು ಮಾರ್ಚ್ ಅಲ್ಲಿ. ಬಟ್ ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟಿರೋದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು ಮಾರ್ಚ್ ಅಲ್ಲಿ. So I am claiming the 7 months. I leave it to your lordship.
ಬೇರೆ ಕಂಪನಿ ಜಾಯ್ನ್ ಆಗಿರೋ ಸಮಯ ಹೈಯರ್ ಇನ್ಕಮ್.
ಇಲ್ಲ, ಬೇರೆ ಕಂಪನಿ ಯಾವಾಗ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ, ಸ್ಯಾಲರಿ ಯಾವಾಗ ಬಂದಿದೆ?
ಅದ್ರದ್ದೇ ಇಲ್ಲ
ಮಾಡಿದೀವಿ.
up to
See, what happens in the private sector,
Please, please, my lord. What is the loss during
see,
that period, my lordship was thinking?
December accident.
Ah.
In January, he has received December's payment.
Oh.
So January he'll be unemployed till he gets a fresh job. He may be sure, if that bank statement, he doesn't have any income by way of salary, that period will have to be paid. The next income which he has received from a fresh new company, that day will be the cutoff date.
What is the loss for that tax?
So from January, since January you have to give, because that amount which he has received in January is for the December.
Yes.
January, February, March, April, May, June. If he has joined in July, then till June you will have to pay. That you see the records,
Please note this.
bank statement.
Continue,
Counsel
Kelly, note.
for respondent number 2 seeks time, relist on.
9, 8 or 9.
Ninth, madam, ninth, madam. 12th or 13th.
12.
Serial number 52, Rangegoda Enna.
Ready, second respond.
Ready?
Yes, Mr. Rangi.
The case of injury. But the date of accident is 11/11/2019. Lord appellant has sustained fracture of femur. Age of the injured my lord 23 years. Avocation by not the fitter in Denso Kirloskar, earning my lord 20,000 per month. In paragraph issue number 2, my lord, paragraph 10 of the judgment, detailed discussion. Inpatient for a period of 6 days.
Inpatient for?
6 days.
Okay.
My lord, tribunal, my lord, after considering the evidence, consider the income of the injured, my lord, 9,500 instead of, my lord, 14,000. Date of accident is 11/11/2019.
9,000 ತಗೊಂಡಿದಾರಾ?
Please,
Should be taken.
14,000. And my lord, doctor has assessed the disability, not 42% to the lower limb, 14%
Fracture of the neck.
neck of femur.
Neck of femur.
Please. 42% to the lower limb and 14% to the whole body. Tribunal may not considered 8% instead of 4%, 14% whole body disability.
It is united as per the doctor evidence. So.
Then my lord, pain and suffering 40,000 has been granted. Then attendance, food, nourishment charges, my lord, 1,800 has been granted. Medical expenses, my lord, actual 1,70,260 has been awarded.
Actual,
Please. Then laid up period, my lord, only 19,000 has been given. 2 months.
28,000 to be given.
Loss of amenities, my lord,
in 2 months.
2 months, 28,000 ಕೊಡ್ಬೇಕಾಗತ್ತೆ. 14,000.
2 months is enough to recover.
3 months.
Fracture ಇದೆ.
ಯುನೈಟ್ ಆಗಿರೋದ್ರಿಂದ
ಏನೇ ಮಾಡಿದ್ರು ಯುನೈಟ್ ಆಗಿದ್ರು it will take time.
Future medical expenses, my lord, doctor has stated in evidence around cost of another, he needs one more surgery.
What has the doctor said?
He said, my lord, around 60,000. Petitioner needs so another surgery of the approximate cost of the surgery is around rupees 60,000.
Yes.
Loss of amenities, my lord, only 20,000 has been
Hmm.
paid.
Earning capacity will increase.
Please.
Yes, sir.
Not produced any cost of estimation, 60,000ಕ್ಕೆ. But 60,000 ಹೇಳ್ತಾರೆ, but they have not produced any cost of estimation ಅಂತ next ಇರ್ಲಿ.
The future medical expense.
ಅಲ್ಲ ಇದಕ್ಕೆ ಕಾಸ್ಟ್ ಆಫ್ ದ ಸರ್ಜರಿ 60,000 ಹೇಳಿದಲ್ಲ ಅದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. 14,000 ತಗೊಂಡು ಮಾಡ್ಬೋದು. ಇನ್ನು this one is
15,000 income.
loss of earning capacity, income.
What about disability?
Disability, it is 12%.
1/3, my lord.
Because as per the chart,
42% lower limb.
as it is
Third, my lord,
united,
14%
12% can be taken.
What has the doctor said? It is united.
It is united, he said, doctor said. 11. Yes. Admitted that the fractures are united and the petitioner can do his work with difficulties. In page 12, para 11, last lines. Right lower limb, but 42% and to the whole body 14%. During cross-examination, PW2 admitted that the fractures are united and the petitioner can do his work with the difficulties.
With difficulties.
ಈಗ at present, next it will
Become all right. What is the age? 23 years.
23 years.
Fracture of
Femur.
Femur.
Depositionally closed traumatic, right?
But is
both
there any
cervical fracture of
any
neck of
judgment
the
which says
right femur?
the fractures
It's
are
fracture of
united?
the.
Here, Ray, mister,
Please.
discussing with him, we are arguing. Is there any judgment which says if the fractures are united, the disability opined by the doctor should be reduced?
United reduce agaya some normally. If it is small united, it is difficult. It is united clearly.
Correct.
But slowly it will some limping ಆ ತರದಲ್ಲಿ ಇರುತ್ತೆ, but ಅದಕ್ಕಾಗಿ we are considering that one.
So what is your submission?
That is 12% can be taken as per our chart.
Normally, my lord, this court considered 15%, I think.
ಅಲ್ಲ
In case of
socket and edge
fracture
of
of
femur
femur.
12%. Femur introcantate condyle ಇದ್ರೆ 12% ಇಂದ 15% ಅಂತ ಹೇಳುತ್ತೆ. ಬಟ್ ಇದು ಹೆಡ್ ಆಫ್ ಫೀಮರ್ ಇರೋದ್ರಿಂದ 12% can be taken.
Neck of the right femur. ಇದು ಕೊಡಿಮ್ಮ. Chart. ಇಲ್ಲ. A photograph of that femur ನೋಡೋಣ. Neck of the femur. Right femur shaft.
Hip joint and thigh bone ಅಂತ. Socket and head of femur.
Neck of the femur will be by the hip alva.
ಹೌದು.
Tip, yes.
That will not become
ಅದು ಇಲ್ಲ ಆ ತರದಲ್ಲಿ ಇಲ್ಲ. ಸಾಕೆಟ್ ಅಂಡ್ ಹೆಡ್ ಆಫ್ ಫೀಮರ್ ಅಂತಾರೆ. ನೆಕ್ಸ್ಟ್ ಫೀಮರ್ ಇಂಟ್ರೋಕ್ರಾಟಿಕ್ ಕಾಂಡೈಲ್ ಎರಡಕ್ಕೂ 12 to 15% ಅಂತ ಹೇಳ್ತಾರೆ. ವೆನ್ ಇಟ್ ಇಸ್ ಯುನೈಟೆಡ್ ಇಟ್ ಇಸ್ 12% ಇಸ್ ಏನಪ್ಪ ನನ್ನ
ಎರಡಿದೆ ಇದರಲ್ಲಿ ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ.
Yes, that's all.
Yes.
Good. Take down. The appeal is preferred by the appellant claimant, challenging the judgment and award dated 7029 of 2019 in MVC. So dated 12/3/21 in MVC 7029 of 2019, passed by the First Additional Small Causes Judge and MACT Bengaluru. Appeal is premised on the ground of inadequate compensation awarded by the tribunal. Party shall be referred to as per the status before the tribunal. Tribunal para has awarded total compensation of fees 4,45,220 with interest at 9% per annum. Directed respondent number 2 insurance company to deposit the compensation within 30 days from the date of the order. Full stop. Para. It's a vehement. Contention of Bernard Council for the claimant. Now, the tribunal is committed an error in awarding inadequate and meager compensation without taking into consideration the materials placed on record, both oral and documentary. Full stop. The tribunal has also failed to take into consideration the proper income and has assessed a lower income. Full stop. It is also contended that tribunal has committed a gross error in assessing disability at ಎಷ್ಟು percent ತಗೊಂಡಿದ್ದಾರೆ disability?
8%.
8%. At a disability at 8%, whereas doctor PW2 has opined whole body disability at 14%. Therefore, the disability ought to have been taken at 14% and the income ought to have been assessed at 14,000 rather than 9,000. It is also contended that on other heads also, tribunal is awarded inadequate compensation which requires to be enhanced. On these grounds, he seeks to allow the appeal, consequently enhance the compensation. Full stop para. Per contra, learned counsel representing the respondent insurance company contends that the tribunal has passed a just and reasonable award, which does not call for interference. It is contended that due to lack of proof of income, tribunal has taken the income at 9,000, which does not call for interference. The disability assessed by the tribunal is correct to the extent of 8%, as the doctor PW2 himself has admitted that the fractures are united. Therefore, the claimant being young at age, the disability would diminish in the future. Under the circumstances, he contends that the on other heads also, just and reasonable compensation has been awarded, which does not call for interference at the hands of this court. Having heard para learned counsel for the claimant and learned counsel for respondent insurance company, having perused the materials placed on record, both oral and documentary, and the impugned judgment, it is seen that the occurrence of accident, involvement of the vehicle, injuries sustained by the claimant have been proved and established by production of exhibits P1 to P22. Negligence is rightly attributed against the driver of the offending car. Full stop. Now coming to the aspect of age, avocation, income, disability and appropriate multiplier. Age of the claimant was 23 years as on date of occurrence of accident. The tribunal has rightly taken the multiplier at 18, which does not call for interference. However, income taken at 9,500, please, 9,500 is on the lower side. The same would have to be enhanced to rupees 14,000 as the accident occurred in the year 2019 and the Legal Services Authority chart prescribes 14,000 as notional income. Full stop. A doctor PW2 has opined disability to an extent of 42% to right lower limb and whole body disability at 14%. Though the doctor has stated that the fractures are united, it appears that the fracture is at the neck of the femur shaft. Therefore, I do not find any good reason or grounds made out to reduce the compensation by the tribunal, as no proper reasoning is given by the tribunal for reduction of the disability opined by the doctor. Under the circumstances, the disability is retained at 14%. We'll stop para. I'll continue. In view of the above, the loss of future income due to disability would be 14,000 into 12 into 18 into 14.
4,23,000.
4,23,360. As against 1,64,160. Full stop para. Towards pain, shock and agony, the tribunal has awarded 40,000. Deem it appropriate to award additional 10,000 under this head. Towards medical expenses, 1,70,260 awarded is retained. Towards food, nourishment, attendant charges, 6,000 is awarded as a claimant was inpatient for 6 days, as against 1,800. Towards loss of income during later period, at the rate of 14,000 per month for 3 months, recuperation period, 14,000 into 3. 42,000 is awarded as against 19,000. Towards loss of amenities, 30,000 is awarded as against 20,000. Towards future medical expenses, 45,000 is awarded as against 30,000. In view of the above discussion, the claimant would be entitled to total compensation of rupees 7,66,620 as against 4,45,220. Accordingly, I pass the following order. Appeal is allowed in part. Judgment is modified. Claimant is entitled to 7,66,620 along with interest at 9% per annum. Full stop. Enhanced compensation shall be paid or deposited with before the jurisdictional tribunal. Please. Before the jurisdictional tribunal, which shall carry interest at 6% per annum. The same shall be deposited within 4 weeks from the date of receipt of copy of the order. All other terms stipulated by the tribunal stand intact. The amount shall be released and dispersed in terms of the order of the tribunal to by way of electronic transfer to the account of the claimant upon furnishing the bank details.
Oh, Mahesh Faratu. Unmute ಮಾಡ್ಕೊಳ್ಳಿ sir. Oh, Mahesh sir.
Yes. I appear for art.
Nagaraj Reddy. System. Yes, Mr. Mahesh, you are ready in this case.
I am ready, Milord. I am for respondent. Their appeal is for enhancement.
ನಾಗರಾಜ್ ರೆಡ್ಡಿ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. We'll have it next week.
Please.
All right, there is no representation for appellant. Counsel for R2 is present. Read it on. 9th August. All right. 9th August, sir.
Please.
For the second response.
Claimant appeal for enhancement, case of injury. Two seven 2018 accident, my lord. My lord, in this case, my lord, two claim petition is filed. One is minor death and another one is injury.
You know,
Two claim petition is filed, my lord. One is minor death, another one is injury case. Minor death settlement before the Lok Adalat, my lord, already. This case is injury case, my lord. My lord. 2/7/2018 accident.
ಸೆಟ್ಲ್ ಆಗಲ್ವಾ?
ಆಗಿದೆ, ಇದಾಗಿಲ್ಲ.
ಇಲ್ಲ ಬಂದಿದ್ರು ಅವ್ರ ಪಾರ್ಟೀಸ್ ಬಂದಿದ್ರು ನೋಡಿದ್ವು ನಾವು. ಅವರು ಅಸೆಸ್ಮೆಂಟ್ ನಮ್ದು ಅನಲೈಸ್ ಮಾಡಿದಾಗ 50% ವಿ ಬೋತ್ ಆರ್ ಅಗ್ರೀಡ್. ಬಟ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ಗೆ ಅವರು ಅಲ್ಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ, 100% ಇದ್ರೆ ಮಾಡ್ತೇವೆ ಅಂತ ಕಂಪ್ನಿಯವರು ಇದ್ ಮಾಡ್ದಾಗಿಂದ, ಹಾಗಾಗಿ ಬೇಡ ಅಂತ ಇದ್ ಮಾಡಿದ್ವಿ. 50% ವಿ ಹ್ಯಾವ್ ಅರೈವ್ಡ್ ಮೇನರ್ that 50% may be considered instead of 26% as considered by the MSCT. Future prospects may be added. ಅದು heel pad ಅವನಿಗೆ ಇದಾಗ್ಬಿಟ್ಟು ಕ್ರಶ್ ಟೈಪ್ ಆಗ್ಬಿಟ್ಟು ಅವನಿಗೆ ಫುಟ್ ಮೇಲೆ ನಿಂತ್ಕೊಳಕ್ಕಾಗಲ್ಲ ಬಹಳ ಹೊತ್ತು. ಯು ಹ್ಯಾಸ್ ಟು ಯೂಸ್ ದ ವಾಕರ್, ದೆನ್ ಓನ್ಲಿ ಹ್ಯಾಸ್ ಟು ಆಪರೇಷನ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಡಾಕ್ಟರ್. ಆಪರೇಷನ್
Disability 50% agree. What is taken by the tribunal?
26%.
26%. So 50% disability ತಕೊಂಡು future prospect ಕೊಡ್ಬೇಕು.
Remaining gets, my lord.
Remaining
gets, my lord. Parents suffering of loss of immunity, so. Pain and suffering only 50,000 is awarded.
Pain and suffering last ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮಾಡೋದಲ್ಲ ಸ್ವಾಮಿ, ಅದೇ ತರನೇ ಇದನ್ನು ಇನ್ನೊಂದು 25,000 ಅದಕ್ಕೆ ಆಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. 50,000.
This is at the internal page 26, judgment page.
Yes, 20.
ಅದೇನಾ?
Yes, my lord. 1722, my lord, judgment. Page number 17, para 22, my lord. MUC 6437 of 18, my lord. Page number 17, para 22, my lord.
CC 6437.
6437 of 18.
437 of 18, my lord.
No, the table is made by.
Table is made in para 25 minutes.
Yes.
ಅದನ್ನೇ ಮತ್ತೆ ನಾನು
ಅವ್ರು ಟೇಬಲ್ ಅವರು ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ಅಂತ ಕನ್ಫ್ಯೂಸ್ ಮಾಡಿ.
ಟೇಬಲ್ ಇದರಲ್ಲಿ ಪೇಜ್ 26 ಅಲ್ಲಿ ಇದೆ.
26 ಮೇಲೆ.
para 25. ಅದೇ ಅಲ್ವಾ ಇದ್ರು?
ಅದೇನು.
So in which all head you are seeking?
My lord, pain and suffering only 50,000 rupees awarded, my lord. In case
the injury is
injury, severe head injury no ಇದೆ. Severe head injury no ಇದೆ.
Head injury.
ಹೌದು.
Heel pad injury, head injury and heel pad injury.
So what is a head injury?
My lord, head injury.
Regarding head injury is concerned, my lord. Internal page
20.
Closer fracture of right second third proximal and right heel done deglowing injury to right heel pad. And so far as the head injury is concerned, my lord, PW4 doctor who has stated that right frontoparietal region was fracture.
Which paragraph?
My lord, paras
F, my lord, F. The permanent disability sent.
Page number 22, my lord. Para F.
Yes. Odi adu one sorry.
Yes. My lord, the petitioner has contended that due to the accident, he was impatient at RL Jalapa Hospital, Bangalore, and sustained permanent disablement. The petitioner also examined Dr. Arun HS and Dr. Srihari BZ, working as orthopedic surgeon at RL Jalapa Hospital, Bangalore, and assistant professor department of neurosurgery at BMCRISSH, Bangalore, as PW3 and PW4. Further, PW3 deposed that he has sustained deglowing injury over the right heel pad 20 into 5 into 2 centimeter on sole, exposing tendon muscles along with bleeding from wound site, abrasion along with
confusion over the right front
That is
parietal
confusion,
region.
not confusion. Confusion.
Confusion ಅದು. Right front
Tribunal
parietal
judge confusion. Allagiರೋದು confusion.
confusion over the right front parietal region measuring 4 into 2 centimeter, head injury and underwent wound debridement and settering of right heel was done for degloving injury of the right heel pad. Closed fracture of right second and third proximal phalanx with undisplaced lateral malleoli fracture was managed conservatively. The PW4 has reported that the petitioner has sustained contusion at gray and white matter junction, thalamus and temporal region, and he was treated anti-edema, anti-epileptics and antibiotics and advised for neurologist opinion and MRI brain. It shows that multiple foci of old hemorrhagic residue scattered in super and infratentorial brain parenchyma. The Dr. PW3 has assessed the total physical disability of the lower limb at 76% and to the whole body at 25%. PW3 is the orthopedic surgeon, my lord. PW4 is the neurologist, my lord. The PW4 doctor has assessed the disability of the 71% to the whole body disability. In order to prove his disability, Dr. PW3 has produced disability calculation sheet, 4 cases sheets and X-rays marked at exhibit P30 to 35. As per exhibit P30, disability calculation sheet shows that patient has sustained disability to right lower limb at 76% and 25% to the whole body disability. PW4 doctor has produced exhibit P37, wherein it shows that petitioner has combined neurobehavioral and cognitive disability at 43.33%, my lord. These documents shows that the petitioner took treatment in the said hospital for the injuries sustained by him in road traffic accident, my lord. My lord, tribunal is only considered, my lord, physical disability, my lord. They have not considered, my lord, neurological disability, my lord. Cognitive disability is the 43%, 43.33%, my lord. But I produced the exhibit P37, my lord, neurological and cognitive disability certificate, my lord. Okay, 26% only considered, my lord, whole body disability, my lord. He was impatient for 150 days hospitalization, my lord. At the time of accident, my lord, 21 years.
43% is neurocognitive disability.
Yes, my lord, cognitive disability, my lord.
25% whole body disability.
Whole body disability, physical disability, whole body.
How much should be taken?
My lord, I will agree with 50%, my lord. As per ಲೋಕಾತ್ ಅಲ್ಲಿ ಲೋಕಾದಲ್ಲಿ ಅವರು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಆಡ್ ಮಾಡಲ್ಲ ಅಂತಂದ್ರು.
ಮಾಡುವ ಇವಾಗ
ಅಲ್ಲ
ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ
ಪ್ಲೀಸ್
ಅಷ್ಟೇ ಅಲ್ಲ 50% ತಗೊಂಡು ಮಾಡೋದು
50% ಮಾಡ್ಬೋದು. ಆಮೇಲೆ ರಿಮೈನಿಂಗ್ ಎಡ್ಸ್ my lord, pain and suffering only 50,000 increase the said, my lord, and loss of emanates only 10,000, my lord.
ಅದು increase ಮಾಡುವ
ಇನ್ಕಮ್ my lord 11,688 ತಗೊಂಡಿದ್ದಾರೆ. 2018 ಆಕ್ಸಿಡೆಂಟ್ 11,688.
ಪ್ರೂಫ್ ಏನಾರ ಇದೆಯಾ?
ಎಕ್ಸಿಬಿಟ್ P21 ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಿ ಇಂಜೂರ್ಡ್ ಆಸ್ ಎ ಡಿಪ್ಲೊಮಾ ಹೋಲ್ಡರ್, my lord. Diploma holder at the time studying in part time ಇದು ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು, ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು. ಅದ್ರ ಸಲುವಾಗಿ ಅವರು ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. He was a diploma holder, my lord.
All right.
21 years.
ಸೊ ಎಷ್ಟು ಹೇಳಿದ್ದೀರಾ?
ನಾವು 20,000 ಹೇಳಿದ್ದೀವಿ.
ನೀವು ಹೇಳಿದ್ರ?
ಹೌದು. My claim is 20,000, my lord.
Which is the year of accident?
2018, my lord.
So chart value is 12,500. What is taken by the tribunal?
11,688 rupees, my lord.
11,688. 688.
As per exhibit P21 bank statement. Part time ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್.
And he was doing diploma.
Yes, my lord, diploma holder.
Yes, how much can be taken?
ನಾನು ಡಿಪ್ಲೊಮಾ ಓದಿದ್ದೇನೆ. Cross examination is admitted, my lord.
They themselves has produced the documents, my lord. The documents itself reflects that 11,688 is the income. He stated that, my lord, his gross salary would be 20,000. But as per bank statement, it is showing that 11,688. Lordship may consider the chart income, 12,500.
Consider
The notional income may be considered 12,000. ಯಾಕಂದ್ರೆ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಅದನ್ನ.
12,500.
ಅಷ್ಟೇ ತಗೊಳ್ಳಿ ಸರ್.
No, 12,500 notional income can be taken for those people who have absolutely no document of their ability to work.
Please, my lord, but here, my lord, they are themselves has produced the document. The document reflects, my lord, 11,000.
Not for this disability. ಒಂದು increase ಆಗುತ್ತೋ ಇಲ್ವಾ?
ಸಮಯ ಇನ್ಕ್ರೀಸ್ ಆಗುತ್ತೆ, ಬಟ್ ಅವ್ರು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಗೋಸ್ಕರ
Holder ಗೆ ನೀವು can you equate diploma holder to coolie?
Can't be.
ಅದಕ್ಕೆ something more has to be given.
Further, one more submission, my lord. Exhibit P23, driving license is produced, my lord. LME driving license, my lord.
LMB driving
Yes,
license.
yes.
LMB driving, ನಿಮ್ಮ ಹತ್ರ LMB ಇದ್ರೆ driving license ನಿಮ್ಮದೇ ಇರುತ್ತೆ.
But produce it, my lord.
No, your case is not that you are a driver, professional driver.
No, his job is, he was working in a Blue Dot Enterprises, my lord. In the
ಇಲ್ಲಿ minimum 20,000 ಸಿಕ್ಕತ್ರಿ.
ಅಲ್ಲಿ ಬ್ಲೂ ಡಾಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಬ್ಲೂ ಡಾಟ್ ಅಲ್ಲಿ he was doing the job of pickup and delivery goods in the said company.
ಈ ಸ್ವಿಗ್ಗಿ ಝೊಮ್ಯಾಟೊ ಎಲ್ಲ ಬರ್ತಾರೆ, ಎಷ್ಟು ಬರುತ್ತೆ ಅವ್ರಿಗೆ ಸ್ಯಾಲರಿ? ಎಷ್ಟು ಕೊಡ್ತಾರೆ ಅವ್ರಿಗೆ ಸ್ಯಾಲರಿ?
ಈ ಝೊಮ್ಯಾಟೊ ಅಂದ್ರೆ ಬೇಸಿಂಗ್ ಆನ್ ದ ವರ್ಕ್ ಮೇಲೆ
So
ಯಾವ ತರ ವರ್ಕ್ ಮಾಡ್ತಾರೋ ಅದ್ರ ಮೇಲೆ
what is the age?
ಡಿಪೆಂಡ್ಸ್.
21 years, my lord.
22 years. 22 years.
So you
Same
can-
multiplier 18.
ಎಷ್ಟು ತಗೊಳ್ಬೋದು? $12,500 is for coolie. Now he's a diploma holder. He is also working in some Blue Dot company.
Blue Dot.
Even if he works as that delivery boy, he'll be getting good amount.
14,000 tons.
I had the same amount in my mind.
That's what I read out my lord's mind.
All right, 14,000.
Please. My lord, 21 years, he is not married, my lord. Marriage prospects to be considered, my lord. Already my friend is
1 year.
22, my lord. Conclusion is 22.
Multiplier will be 18.
18, my lord.
ಬರ್ಕೊಳ್ಳಿ. This appeal is preferred.
My lord, one submission, my lord. I have filed the application, my lord. Evidence after accident, my lord, purchasing the medical bills, my lord, 67,000 rupees on our. Application ಹಾಕಿದ್ದೀನಿ sir. Post ಆಗಿದೆ.
I have verified that, my lord, approximate 50,000 may be granted. Future medical expense.
Future medical expense.
ಅದು on medical bills or medical?
Medical
Bills,
bills.
Medical bills.
Outpatient medical bills, my lord.
ಇಲ್ಲಿ claim petition ಕೊಟ್ಟಿಲ್ಲಲ್ಲಮ್ಮ. Appeal you have not given dispensation ಇದೆ ಇದು. ಇದೇನೆ dispensation ಆಗಿದೆ. ಕರೆಕ್ಟ್ ಇದೆ. ಈ dispensation ಅಂತ ಇದಾಗಿದೆ. ಕರೆಕ್ಟ್ ಇದೆ. ಇಲ್ಲಿ dispensation ಅಂತ correct, MF is correct. ಬರ್ಕೊಳ್ಳಿ. This appeal is preferred. ಇದೆ. Preferred by the appellant claimant, challenging the judgment and award dated
2/7/2018, my lord.
1st December ಅಲ್ವಾ?
2nd July.
Huh?
July, date of accident, my lord.
Judgment dated
1/12/2022, my lord.
in MVC 6437. ಎರಡಿದೆಯಾ ಅದರಲ್ಲಿ?
ಅದೇ ಒಂದ್ ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಒಂದ್ ಸೆಟ್ಲ್ ಆಗಿದೆ.
6437 of 2018 passed by additional small causes judge and MACT at Bengaluru. Full stop. The appeal is premised on the ground of inadequate compensation awarded by the tribunal. Party shall be referred to as so and so. Tribunal has awarded total compensation of
12,46,000
12,46,892.
along with
along
9%.
with interest at 9% per annum. Fastened the liability against the insurance company and directed the insurance company to deposit the compensation within 3 months. Full stop. Para. It's the vehement contention of learned counsel for the appellate. And the tribunal is awarded inadequate compensation without taking into consideration the materials placed on record, both oral and documentary. The tribunal has failed to take into consideration the severe head injury suffered by the claimant and the physical permanent disablement suffered by the claimant. And thereby the assessment made by the tribunal with regard to disability at 25% is erroneous. The same requires to be
26%.
26%. 26% is erroneous. The same requires to be set aside and consequently to be enhanced. It is also contended by learned counsel that the income taken by the tribunal is on the lower side, which requires to be enhanced in view of production of exhibit P21 and the other documents showing the employment of the claimant. Full stop. It is also contended that under other heads also, the tribunal is awarded inadequate compensation, which requires to be enhanced. Accordingly, he seeks to allow his appeal and consequently to enhance the compensation. Full stop. Para. Per contra, the counsel Shri V. Pradeep, representing the respondent number 2 insurance company, vehemently contends that the tribunal is awarded a reasonable compensation on the basis of materials placed on record. And the same does not call for interference. It is further contended by learned counsel that the claimant has not produced any proof of income to show that he is earning what is the income taken by the tribunal?
11,688, my lord.
That
As
is
per
earning more
exhibit,
than
13.
11,688.
21.
As even according to the claimant. As per exhibit P21, he's earning 11,688. Same has been taken, which is justified and sustainable. Therefore, the question of enhancing the income does not arise. Nextly, learned counsel for the insurance company contends that the question of awarding future prospects in this case would not arise, as disability sustained by the claimant is 26%, which is permanent physical disability. He also contends that on all other grounds, the tribunal is awarded just and reasonable compensation, which does not call for interference. Hence, he seeks dismissal of the appeal. Having heard learned counsel for the claimant and learned counsel for the respondent insurance company, though it is disputed by the insurance company, counsel for the appellant claimant has been able to prove and establish the occurrence of accident, involvement of vehicle, injuries sustained in the due to the said accident, the magnitude of the injuries, and so also the disability, both permanent physical disability as well as a neurocognitive disability. Hence, the negligence is rightly attributed against the driver of which vehicle? Car.
Driver of car bearing
Driver of the
PA
pending
51.
car. Full stop. Now, coming to the question of age, avocation, income, disability, and the appropriate multiplier. It is seen that age of the claimant is 22 years.
22 years.
As on date of occurrence of accident. The appropriate multiplier would be 18, which is correctly taken by the tribunal. Full stop. The income is taken at 11,088 on the basis of Exhibit P21. However, it is contended by learned counsel that the said income was on the basis of a part-time employment. Claimant has done a diploma course and he has you produce some document for that?
Yes, my lord, exhibit 13.
Yes,
Exhibit
produced
P13, my
Exhibit
lord.
P13 to establish
Study certificate.
his educational qualification of having done diploma. And that he was working in a private company earning rupees 11,688. Full stop. Therefore, in my opinion, the claimant cannot be equated with a coolie or an unemployed.
At that melody was getting 20,000 per month. But as per the exhibit P21, 11.
That he cannot be equated with a coolie or an unemployed agriculturist. He would have to be awarded something more for having done his diploma course and being employed, as stated by him, earning a sum of rupees 20,000 from the employment. But however, in view of lack of production of the proper materials with regard to income, this court is of the opinion that rupees 14,000 could be taken as the income. Full stop. Doctor has been examined as PW2, who was opined disability.
PW3 and 4.
PW3
And 4.
PW3 and 4. These two doctors are professors in the Department of Orthopedics and Professor of Neurosurgery. The
PW3 is my lord, a treated
PW3
doctor.
has opined physical disability to an extent of 76% to right lower limb and whole body disability at 25%. Whereas PW4, the neurosurgeon, has opined disability to an extent of 43.33%, terming it as combined neurobehavioral and cognitive disability. Despite the evidence adduced by the doctors PW3 and 4, the tribunal has opined disability to an extent of 26%. I'm afraid the assessment made by the tribunal is not correct. And the same is without any basis and material, and hence the same would have to be set aside. And the disability would have to be calculated at 60%.
50 minutes.
50%.
50%.
50% in view of both physical disability as well as neuro, behavioral, and cognitive disability. Full stop. In view of the above disability of 50%, the claimant would be entitled to future prospects of 40% in addition to the income arrived at by this court. Therefore, The loss of future earning capacity due to disability would be 14,000 plus 40%,
5,600.
19,600 into 12 into 18 to 50%. 21,16,800.
Please, ma'am.
As against 6,56,388. Full stop para. The compensation awarded towards medical expenses retained. Towards food, nourishment, medical attendant expenses at 60,000 is retained.
My lord, 150 days inpatient for hospitalization, my lord. Incidental conveyance medical bills, so only 60,000 rupees awarded, my lord.
You were inpatient for 150 days.
150 days, my lord.
Accident was of the year 18,
18, my lord.
The increase ಆಗ್ಬೇಕಲ್ರಿ ಅದು. That will have to be increased. 70,000 is given and 150 days.
Another 30,000 maybe.
1,50,000 at the rate of 1,000 rupees. That's right. It is seen that the claimant was inpatient for 150 days. The tribunal has awarded amount of rupees 70,000 towards food, nourishment, medical expenses, conveyance and incidental charges. I'm afraid the same is on the lower side. 1,50,000 is awarded as against 70,000. Towards loss of income during later period. How many months ಕೊಟ್ಟಿದ್ದಾರೆ?
5 months ಕೊಟ್ಟಿದ್ದಾರೆ, 11,000.
At the rate of 5 months and taking the income at 14,000. Claimant would be entitled to rupees 70,000 as against 58,440. Towards pain and suffering, tribunals awarded 50,000. Same is on the lower side. Additional 25,000 is awarded at this head. Towards future amenities, tribunals awarded 10,000. This court deems it appropriate to award additional 30,000 under this head. Full stop, para. Looking into the magnitude of the injuries suffered by the claimant, both neurobehavioral cognitive disability, permanent physical disability, considering the age of the claimant at 22 years. Being unmarried, the marriage prospects would have to be awarded. Loss of marriage prospects would have to be awarded. This court is of the opinion, rupees 1 lakh be reasonable to award under this head. Accordingly, 1 lakh is awarded. All others are covered. Medical expense, towards medical expenses retained, but 4,02,000. Yes, in all, in view of the above discussion, the claimant would be entitled to total compensation of rupees 854, 64. 29,53,864 as against 12,46,892. Full stop. Accordingly, I pass the following order. Appeal is allowed in part. Judgment and award is modified. Claimant is entitled to total compensation of 29,53,864 along with interest at 9% per annum.
Enhanced compensation would carry 6%.
Oh, ಅದು ಇದು ಕೊಟ್ಟಿಲ್ವಲ್ಲ 50,000 medical bills.
Additional medical expense.
We have to add another 50,000. The one para add ಮಾಡ್ಕೊಳ್ಳಿ after that. Learned counsel for the claimant has filed an application for production of additional medical bills which he was unable to produce before the tribunal under order 41 rule 27 read with section 151 of the Code of Civil Procedure. This court deems it appropriate to allow the application. The documents are taken on board, and on appreciation of the documents and perusal of the same, it is seen that the claimant has undergone several other expenditures. Therefore, an additional amount of 50,000 is awarded towards medical bills and expenditures met by the claimant. So, so 30 lakhs, 3,000.
864.
864. Well, the appeal is allowed in part, appeal is allowed. Appeal is allowed, claimant is entitled so and so, along with the interest of so and so. Next point, enhanced compensation shall be paid with interest at 6% per annum. The same shall be deposited before the jurisdictional tribunal within a period of 4 weeks from the date of receipt of copy of the order. All other terms and conditions stipulated by the tribunal stands intact. Full stop. That's all.
Please.
Claimant appeal for enhancement, Manoj.
Is there rival idea?
Please.
Insurance appeal also is there. Where is
please,
Mr. Hegade? We'll take it up in the afternoon.
Like, he informed that he is not in station, my lordship.
Not in station.
Not in station.
Then you adana helbekalla. Counsel for the insurance company seeks time. Relist on. Gopala Krishna.
Claimant's appeal for enhancement.
Ready?
I represent respondent.
You are ready?
Ready, my.
ನೀವು ಯಾರಿಗೆ ಅಪೀರ್ ಆಗ್ತೀರಾ ಅಶೋಕ್?
Notes, I represent Padma Sutur notes for an insurer, respond number 2.
ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ವಲ್ಲ?
ಇನ್ನು ಹಾಕಿಲ್ಲ. We have forwarded, my lords, it is not sent across.
Coming in
What's the
final
kindly-
hearing or admission? So you want to argue?
Yes, ma'am, I am ready. ma'am.
Please, ma'am. Claimant's appeal for enhancement. Appellant claimant suffered type 3B compound fracture of right left femur and one third of left tibia fracture. The discussion at lordship could get at internal page 10, paragraph 16 and 15 onwards.
Para 15,
15 onwards.
Hmm.
The petitioner stated that he had sustained injuries. He has taken treatment in patient and medical bills produced to the extent of 13,881. The bill number so and so is not for one Pradeep Kumar, which is not belong to petitioner. The petitioner has taken medicine even in December to for which for any other medical not produced. PW doctor has assessed the disability 20% whole body and 62% of the left lower limb. He has admitted in his case that fractures are united and until the gate mentioned at para is up to bit means the patient had pain, then put his foot on the floor. The disability assessed after 4 years of the accident and the doctor has admitted that he was not treated. Though the doctor says that there is a disability of 20%, this court found no functional disability as the fracture is united. Considering the nature of injury, treatment taken petition, his age and date of action, I deem it proper to award 40,000 global compensation only, my lord. He underwent surgery and he was inpatient for about 36 days
in 3 hospitals and lordship PW to examination and discharge, I produce discharge summaries and
20% disability and 40,000 rupees global compensation ಕೊಟ್ಟಿದ್ದಾರೆ.
without going to any discussion. Any discussion ಇಲ್ಲ ಅಷ್ಟೇ. Examination of PW to lordship type 3B. Type 3 means that is a very serious impact. That is almost near to amputation. Compound fracture left femur and middle 1/3 of left tibia fracture. And he was treated as inpatient in 3 hospital for about 36 days. Underwent surgeries. And discharge terms also produced.
What is this, sir? How will you sustain this kind of judgment? 20% disability in child. Doctor. Tribunal ignores everything.
Yes.
Global compensation 40,000.
But there is
Absolutely no application of mind.
But kindly see, my lords, I want to, my lords, bring to your lordship notice, the accident, my lords, occurred on 16/11/2014. My lord, the facts are, my lords, the petitioner, the victim, my lords, was riding a motorcycle. Along with the 3 pillion riders on a highway, my lords. And this accident occurred at around 10:30 PM in the night. But though, my lords, there is no evidence from our side. With regard to, my lords, negligence or contributory negligence on the part of the, my lords, victim. The facts would, my lords, indicate that 3 pillion riders along with the rider, my lords, were going on a national highway during night, my lords, at around 10 PM. 10:30 PM. And the, my lords, it is the car which is the offending vehicle which has come and hit, my lords. How? Kindly also see, my lords, exhibit.
I've come in appeal for enhancement, not for negligence.
No, my lords, I am not on that. But exhibit P11, my lords, may I pass on, my lords, for a moment.
ಏನಕ್ಕೆ?
ಇದರಲ್ಲಿ the final diagnosis, my lords, would indicate RTA injury or to left leg 2 months old, 2 months old fracture distal 1/3 left tibia only is mentioned, my lords, somehow. From the discharge summary, my lords, I could make out. There is no, my lords, indication of fracture to the femur.
And the wound set, exhibit P9, the wound certificate, there itself it mentioned. Exhibit P9 the wound certificate, just.
Records ಇದೆಯಮ್ಮ?
ಇದೆ.
It's
exhibit P11, my lords.
Exhibit P9, my lord. That all subs. Wound certificate, the earliest.
The claim petition is filed in the year 2017, my lord. The boy who was the victim was a minor aged about 17 years. He was riding, my lords, along with 3 pillion riders. He was a, my lords, a minor aged about 17 years from the records which will, my lords, because the Aadhaar card is produced. And further from the evidence of the doctor, my lords, since the fracture is united, my lords, the global compensation, my lords, I would not, my lords, sustain this order.
Accident is of the year 14.
14.
17 ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ he was 22 years.
Yes.
So minus 3 years. He'll still be major only.
Illa, kindly see, my lords, paragraph 11 of the judgment. Exhibit P12 is the Aadhaar card which is produced, my lords. His date of birth is 1997. So he'll be 17 years.
Petitioner was minor and was old at the time of accident.
All right, but you are not in appeal.
Not in appeal.
We are not in appeal.
So you want to file anything, go through and then make your submission, I can give you time. Otherwise, I'll dispose it.
My lords, at this stage.
Thing is, you are not in appeal.
Yeah, we are not in appeal, but we have not led any evidence, my lords.
Second thing with regard to the triple riding, not having license, there's nothing material on record. You have not led evidence.
But he's 17 years of age, my lord. There is no chance of, my lords, him having any driving license for a motorcycle.
Correct.
Because he is disqualified for holding, but not
Maybe.
driving license also.
How will he be barred from getting the compensation?
No, but I'm making out a point.
See,
That
that's
much.
why if you remember, Mr. Patil, last time when I was sitting here, I have written a judgment
Yes.
that the police authorities and the court, while dealing with this matter, immediately should have taken cognizance of the fact and
ನಮ್ಮ ಕೇಸಲ್ಲಿ.
penalized him for that particular offense of not possessing driving license and riding triple riding,
Yes.
which is provided under the IPC.
Yes.
Then prevalent IPC. So it is for the investigating agency or the police and the court. They should have done that, but he does not get deprived because there is no contributory negligence by him by virtue of any piece of evidence or FIR,
Yes, Manoj, yes.
which is also what the Supreme Court says in that full bench judgment.
Mohammed Siddiq.
Mohammed Ansar,
Mohammed Siddiq.
Mohammed
Siddiq.
Siddiq, correct. Justice Ramanas.
Ramanas. Yes, Manoj.
Last judgment. So what you should do, at least at the stage of the MVC court tribunal, you should ask them to punish him and pay the deposited before the court. Tribunal should do this. Otherwise, we are not going to improve our system on the roads. We'll still continue granting from here. Nothing changes. So eventually, we have to, after doing all this, the court also should start granting 50%, awarding 50% contributory negligence. Only then we will rectify the system.
Yes, Manoj.
Illandre, it keeps on going like this.
But I would seek instructions, Manoj, in this case and make my submissions because still Wakalat also is not issued, Manoj.
That's
I've
why
been
I asked you.
repeatedly- I will, Manoj, I will seek some instructions and.
Please. Counsel for respondent seeks time to file wakalat and take instructions, relist on two weeks.
Vijay Kumar.
D. Vijay Kumar for respondent.
My lord, serial number 60, my lord.
Yes.
My lord, in this case, I seek 2 weeks time, my lord. Because the similar matter is pending in the division bench. The matter was argued.
Death of a just 11 years old girl, my lord, tribunal award only 5 lakhs. That's what I am coming appeal.
7-year-old.
11 years old girl.
11-year-old.
Old girl.
Is there any other appeal pending?
No, no, my.
Have you filed any appeal?
No, no. He has not filed any appeal.
No, we have not filed appeal. The similar matter is being heard by the division bench.
No.
What is the compensation to be awarded? My lord, I have to wait for that judgment, my lord, that is be binding on this court.
Not binding on my, this is all
Why not?
different facts.
No, no, wait.
Different facts, my lord.
Let us see, let us see.
Last
Well,
time also my learned friend took the time and I am on point that they're relying on Kishan Gopal case that was rendered accident of the year 1992. And again, one more case, my lord, that is Meena Devi case. That in that case, 5 lakhs granted, that is accident, it was in 2004. Now it is accident of the year 2017.
What about one
We
more
are
case
relying
of
upon
that
those two judgments.
Ansari's
Even the
case
criminal
also
also
is-
relying upon those judgments only.
No,
Awarded
which is-
discount reasonable compensation.
Notional income assessed by the tribunal for.
Mr. Vijay Kumar, which is the case you are awaiting to argue
My lord,
this
that
case?
MFA, my lord.
I'm relying on Supreme
My
Court.
lord,
judge. Why I should
ಸ್ವಲ್ಪ
wait?
ತಾಳಿ ಒಂದ್ ನಿಮಿಷ ಗೋಪಾಲ್ ಕೃಷ್ಣ ಇಲ್ಲ ಅದೇನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡಿ ನಾನು ಮಾಡ್ತೀನಿ
ಮಾಡಿನಿ.
My lord, MFA 468/23, 456/23 and 820/23. It was argued before the division bench on 25/7/2024. My lord, I have to wait for the result of the judgment on the very same point.
Why this court should wait for that?
My lord, because if lordship is following the Kishan Gopal's case and another case of the Supreme Court judgment granting 5 lakh, then madam, I have no objection. I'll go on with the matter.
No,
If
no.
your lordship
whether-
wants to differ,
Whether the division bench matter is hearing any reference matter or it is just a appeal by the division bench, before the division bench? Is it any reference matter?
No, it is not a reference matter, but this
why
matter is
this
being
court should
heard
wait?
only regarding that point.
And why this court should wait? You argue.
Kindly call this matter next week.
Reference idre, if there is some
Reference
conflict.
ಏನilla, but this court is, the division bench is considering the very same point. Whether to rely upon the Supreme Court judgment or this type of this.
I am relying on Supreme Court judgment, not.
All right, you have to argue that, sir, unless the coordinate bench judgment, single bench judgments are referred to larger bench, then it would make sense for this court to wait. Otherwise, there is no need for me to wait.
Call next week, my lord. I'll go on with the matter. Any date.
Any date may be given.
Tuesday, Akanwa?
Wednesday, Thursday.
All right. Learned counsel for respondent. Number 2, seeks time. List this matter on
7th August.
7th. 7ನೇ ತಾರೀಕು, Mr. Vijay Kumar.
Please, my lord.
All right. On 7th.
61.
This is under Employees Compensation Act, appeal by the claimant.
Been take notice, my lord, it has been entrusted to BC Sitaram now.
ಇದಾ ಅವ್ರ ಹೆಸರು ತೋರಿಸೋದ?
Our
Registry to show the name of learned counsel BC Sitaram Rao and Anupa and Anup Sitaram Rao, and delete the name of learned counsel Shri B Pradeep from the cost list. Call this matter on
12th August.
12th August.
Seal number 62. Srinivasaya.
ನಿಮ್ಮ ಹೆಸರು ಜಗದೀಶ್ ಅಲ್ವಾ?
Jagdish.
ಈ ಶ್ರೀನಿವಾಸಯ್ಯ ಯಾರು?
My colleague, my senior colleague.
ನಿಮ್ಮ ಹೆಸರು ಯಾವಾಗ ಬರುತ್ತೆ?
ಇದೆ ವಕಾಲತ್ತರ signature ಇದೆ.
ಇದೆಯಲ್ಲ?
ಇದೆ.
You should show your name also.
My lords, in this matter, my lords, I request my learned friend to give me a copy, my lords. He may have already served. I have misplaced it, my lords. I request for another copy, my lords.
All right. One copy and I'll list it next week. Anup,
Please, my lords, I'll be ready.
learned counsel for respondent number 2, seeks time. Let's relist this matter on 9th. Counsel for the appellant to furnish one set of copy of the appeal memo to the counsel for respondent number 2. All right, 9th.
63. Shantraj K.
Yes, Mr. Shantraj.
Injured was aged about 35 years, my lord. He was working as a mortar and tailoring work.
Working as?
Mortar and tailoring work.
Working as mortar.
Mortar.
ಏನದು ಅರ್ಥ ಐತೇನ್ರಿ ನಿಮ್ಗೆ?
ನನಗೆ ನಾನು ಅದನ್ನೇ ನೋಡ್ದೆ ಇದೇನೋ ಇವರು ಇದಂತಾರೆ. ಇದರಲ್ಲಿ
ಮಾರ್ಟಾರ್ ವರ್ಕರ್.
ಮಾರ್ಟರ್ ವರ್ಕರ್ ಒಂದೇ ವರ್ಡ್.
ಮಾರ್ಟರ್ ಅವ್ರು ಮಾರ್ಟರ್ ವರ್ಕರ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಟೈಲರಿಂಗ್
ಏನ್ ಮಾರ್ಟರ್ ವರ್ಕರ್ ಕಮ್ ಟೈಲರ್? ಏನ್ ಅದು ಎರಡು ಅಪೋಸಿಟ್ ಅಲ್ವಾ?
ಇದರಲ್ಲಿ ಡಾಕ್ಟರ್ stated disability at 42% and 21% to whole body, but he has taken 21% disability.
No, 10%.
10%. ಇದು you will not spend, see, type judgment page 8 of the judgment. Disability. Wound certificate exhibit 5 reveals the injury caused to the petitioner such as degloving injury of left leg. According to it, the above said injury is grievous in nature. Discharge summary, which is at exhibit P7, shows that the petitioner sustained crush and degloving injury, left knee, leg and foot with tissue loss chip avulsion fracture of anterior superior lip and right octabulum, left leg fibula undisplaced fracture, middle third, and one malunited right neck of femur fracture with subluxation. And petitioner has taken treatment as an inpatient for a period of 8 days in Ravi Kirloskar Memorial Hospital and underwent surgery. It is averred that because of the injuries, he suffered the disablement and from which he lost or lessen his earning capacity. In proof of the disablement, he examined PW to orthopedic surgeon from Boring and Lady Kurjan Hospital, who assessed the disability of petitioner, opined that the petitioner suffered disability of left lower limb at 42% and to the whole body 21%. Is evidence clear that he is not the treated doctor. However, the doctor didn't reduce proportional disability on the whole fracture. So it would say that the assessment of disability may be excessive one. And your last can see the photos has been produced at a and marked as exhibit P13.
What is the disability taken now finally?
10% taken, man. Exhibit P13 photos has been produced. Can you see the photos?
Yeah, records ಇದೆ.
ಇದೆ.
Very good.
ಇನ್ಕಮ್ ಎಷ್ಟು ಕ್ಲೇಮ್ ಮಾಡಿದ್ದವನು
ಫೋಟೋಸ್ ನೋಡಿದಿರಾ?
ನೋಡಿದೆ.
ಮಸಲ್ ಇದಾಗ್ಬಿಟ್ಟು.
How can the trial court tribunal, after seeing all this, arrive at 10% disability beyond my understanding? Doctor has said 21%.
21%,
42% of the limb,
42% to the
21%
limb
whole body.
and 21% whole body. Right? ಇದರಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ 42% ತಗೊಂಡು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಡ್ ಮಾಡ್ಬೇಕು.
To their own medical practice.
ಶಾಂತರಾಜ್ ಏನಾರ ಹೇಳ್ಬೋದು. He can argue. It is left to us and you to counter and defend. ಅವ್ರ ಕೈ ಇಂಜುರಿ ಇನ್ನೂ ಮುಗ್ದಿಲ್ಲ ಪಾಪ, ಅದಕ್ಕೆ ಅವರು ಓಡಾಡ್ತಾ ಇದ್ದಾರೆ.
ಫೈಲ್ ಹಿಡಿಯಕ್ಕಾಗಲ್ಲ, ಇನ್ನು ಸ್ಟಿಲ್ ಪೇನೇ ಹೋಗಿಲ್ಲ ನನಗೆ.
Now, in view of the doctor's evidence himself stating 21%, whether this court can go beyond that?
ಅಲ್ಲ ಅದೇ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಏನೇ ರೀಡ್ ಮಾಡಬೇಕು. ಐದರ್ ಅಂಡರ್ ದ ಆಕ್ಟ್ ಆರ್ ಇನ್ ದ ರೂಲ್ಸ್ ಇಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್. ವಾಟ್ ಈಸ್ ದ ಮ್ಯಾನರ್ granting the compensation? It is courts are doing some work, guesswork and awarding compensation, just compensation. Therefore, my lord,
On the other grounds, we can do that, but court, once you have examined your doctor who's a specialist, you was said 21% to the whole body, we'll take 21%, award future prospects. And pain and suffering and other amenities, enclose. This court cannot sit in the armchair of the expert.
41C2 of EC Act says, medical practitioner evidence has to be looked into. Basing on that, my lordship, what is saying is correct.
Correct. ಅವ್ರು ಇದ್ದಿದ್ರೆ ಜಾಸ್ತಿ ಮಾಡಿಸ್ತಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. All right, afternoon I will.
Yes, madam. ನಮ್ದು ಬೇರೆ ಬೆಂಚ್ ಜೊತೆಗೆ ಒಂದು ಮ್ಯಾಟರ್ ಇರಬೇಕು.
I'll finish that. I don't think it will be much one matter. I'll finish that and probably come back.
Yes, ma'am.
Unless that goes on for the whole day, which is not probable. ನಾನು ಆ ಬೆಂಚ್ ಇರೋದು ಮರ್ತೇ ಬಿಟ್ಟೆ, ನೀವ್ ಹೇಳಿದ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತು.
ನಾನು ಇದನ್ನ ನೋಡ್ದೆ.
So advocates are carefully watching which all bench.
ಅಲ್ಲ ಫ್ರೈಡೆ ನಾರ್ಮಲಿ.
Yes, sir. 67. Huh. Next week. Next week. We'll fix a date. When do you want? 12th, at request of counsel for respondent, give it to respondent number 1, released on 12th.
Serial number 68, my lord.
Hmm.
Next week, my lord, any day.
Or at request of learned counsel for R3 list on 12th.
Yes.
Yes.
Serial number 65 and 66, my lord, is the bench resuming after
six-
lunch.
65, 66. Yeah.
I'll wait, my lord.
Ah.
I'm
Mostly, it doesn't go on for long.
ಇದು RCD ಅಲ್ವಾ? ಇಷ್ಟು ಕೇಸ್ ಬರುತ್ತೆ ಒಂದು.
ಯಾರು ತಿಂತಾರೆ ಅಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ರೈಸ್ ಮಾಡ್ತಾರೆ.
My lords. With my lord's kind permission, may I make one submission, my lord?
Yes, yes.
My lord, serial number 45, my lord, interim order was extended for a period of 6 weeks that requires to be extended, my lords.
45.
Please, my lords.
Interim order was there for only 6 months,
6 weeks, my lords.
6 weeks.
Please, my lords.
Now, who are you appearing for?
For the appellant, my lord.
No, who are you? Owner?
My lord, respondent's appeal, my lord.
No, who are you? Respondent is the owner or your insurance company?
No, I'm the legal heir of the deceased, my lord, the offending vehicle. I challenge the appeal, my lord, the judgment, my lord, wherein.
Liability is fastened on you.
Please, my lords, please, my lords.
No, but you have been directed to deposit the amount and stay is granted.
For a period of 6 weeks, it was granted, my lord.
Where have you deposited the amount?
I'll cross-check and if necessary, I'll file necessary application. my lord.
One lady appeared. That's the matter. In the morning, your colleague or somebody appeared.
No, my
one
lord, I
lady.
myself had appeared in the matter. There was another matter, my lord, that was to be tagged together. I made a submission and accordingly, my lords are pleased to pass an order.
No, if you are appearing for respondents who are the appellant,
Please, my lords.
would have been stay granted subject to deposit of some amount.
No, my lords, no such order was passed, but my lords were pleased to say the impugned judgment is stayed for a period of 6 weeks.
It's a motor vehicles case.
Please, my lords.
Accident case.
Please, my lords.
Other 6 weeks are normally. Don't do that.
May I read the order, my lord? It says.
Read. You have the order with you.
Yes, my lords.
Please read it.
On 2/8/21, my lords. At the learned counsel appearing for appellant on IA 1 of 21, peruse the affidavit filed in support of the application. Being satisfied with the cost shown in the affidavit, the application is allowed. Impugned judgment and award dated 23/3/21 passed by so and so in so and so is for a period of 6 weeks, my lord. That has been stayed.
All right, we'll continue that order.
Grateful, my lord.
You want that order to be continued?
Please, my
Sign
lords.
ಆಗಿರ್ಬೇಕಲ್ಲ. ಬೆಳಗ್ಗೆದು. All right, interim order shall stand continued till next date of hearing.
Grateful, my lords.
It was passed by in the year 2021
Please, my lord, on 2/8/21.
by his lordship.
Lordship, Mr. Justice H.T. Narendra Prasad, my lords.
All right. But yes, it's continued.
Grateful.
63.
21 ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿದ್ರೆ ಎಕ್ಸ್ಪೈರ್ ಆಗಿರ್ತದಲ್ಲ 6 weeks ಅಂದ್ರೆ ಅವ್ರು ಐఏ ಹಾಕೋಬೇಕಾಗ್ತದೆ.
Is any further? Nothing.
Really,
Any further submission you want to?
further submission, my lord, future medical expenses has not been granted.
Not granted?
Not granted, but doctor has not been stated in his affidavit with regard to the future medical expenses. In the nature of injury suggests that he requires future medical expenses.
This is that accident where his leg is
Yes, ma'am.
Date of accident.
deep loving ಎಲ್ಲ ಆಗಿದೆ ಅಲ್ಲ. ಡಾಕ್ಟರ್ ಏನು ಹೇಳಿಲ್ವಾ?
ಹೇಳಿಲ್ಲ.
One submission, my lord. Date of accident 31/8/2021, my lords. After 3 years, my lord, they have any medical bills is they can produce, we will accept that medical bills, my lord. Future medical bills, but they have not produced any future medical bills, my lord. Is treatment taken medical bills, is there any, we will accept it, but they have not produced any documents.
ಏನಾರ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಳಗೆ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಎನಿ ಬಿಲ್ಸ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಟ್ರೀಟೆಡ್ ಫರ್ದರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಫ್ಟರ್ ದ?
ಯಾವ್ದೇನು ಕೊಟ್ಟಿಲ್ಲ. Implants, 4 fractures ಇದೆ.
He was inpatient for how many days?
9 days.
All right, we'll award some nominal amount per call. That's all you want to submit?
No, my lord.
Heard, this appeal is filed by the appellant claimant challenging the judgment and award dated 25/10/22 in MVC 411 of 2021 passed by Court of Small Causes and MACT at Bengaluru. Party shall be referred to as per the status before the tribunal. The tribunal has awarded total compensation of rupees 7,59,400 along with the interest at 6% per annum and directed respondent number 1 insurance company to pay the compensation within 2 months. This is a vehement contention of learned counsel for the claimant. The tribunal has committed serious error in not awarding just and reasonable compensation and has ignored the material evidence, both oral and documentary. The tribunal has what is the income taken?
15,000.
15,000 notional income has been correctly taken.
21 accident.
That's correct, idea.
Correct ಆಗಿದೆ.
Total income has taken.
Tribunal has also failed to award future prospects despite the claimant suffering serious grievous injuries, which has caused severe damage and dent to his future earning capacity. On other heads also, tribunal has awarded meager compensation. Hence, he is before this court seeking enhancement. Full stop. Per contra, learned counsel representing the insurance company contends that the just and reasonable compensation is awarded, which does not call for interference. He further contends that the tribunal has taken the assessment of income and also disability in accordance to the opinion expressed by the doctor. Therefore, no indulgence or interference is called for in the present case. Accordingly, he seeks for dismissal of the appeal. Having heard learned counsel for the claimant and learned counsel for the respondent insurance company, there is no dispute with regard to the occurrence of accident, involvement of the vehicle, injuries sustained by the claimant, as the same are proved and established by production of exhibits P1 to P15. Negligence is rightly attributed against the driver of the truck, canter truck. Full stop para. Coming to the question of age, avocation, income and disability. What's his age? 37 years.
Yeah, I done. DL has been produced.
37 is accepted.
85 has been shown.
The age of the claimant is 37 years as on date of occurrence of accident. That is in the year 2021, huh?
21.
21. The notional income is taken at 15,000, which does not call for interference. Same is retained. Doctor has been examined as PW2, who was opined disability to an extent of 42% to left lower limb and 21% to the whole body, whereas the tribunal, not accepting the opinion of the doctor, has arrived at disability of 10% to the whole body. Full stop. I'm in agreement with learned counsel for the claimant that the assessment made by the tribunal is erroneous and the same requires to be set aside. Accordingly, it is. Once the doctor, who is an expert in the field of medicine, has expressed his opinion with regard to disability to the limb and to the whole body, the same will have to be taken on the face value unless contra material evidence are placed before the court to disprove the opinion so placed by the doctor. In the present case, no such thing is placed and no reasons have been given by the tribunal to differ from the opinion expressed by the doctor. Under the circumstances, I am of the opinion that 21% requires to be taken as whole body disability on the basis of opinion expressed by the doctor. Full stop. Therefore, the loss of future earning capacity due to disability would be 15,000 into 12 into what's the multiplier?
15, my lord.
15,
15.
40% has to be added.
15, huh?
Please, my lord.
All right, so what is the age? 37, 40% will have to be added, huh?
Please, my lord, 40%, future passport.
In view of just strike off that in view of the disability at 20%, which is serious and grievous in nature, which would hamper the further earning capacity. This court is of the opinion that future prospects needs to be awarded in this case on hand. Hence, 40% requires to be awarded in addition to the income. Therefore, 15,000 plus 40% be 21,000 into 12 into 15.
7,93,800.
ಎಷ್ಟಾಯ್ತು? 1,000 into 12 to 15 to 7,93,800.
Please, madam.
7,93,800. Full stop. Para. Towards pain and suffering and loss of income during later period. ಎರಡು ಸೇರಿಸ್ಕೊಟ್ಟಿದ್ದಾರಾ?
Please, madam.
6 months later period ಕೊಟ್ಟಿದ್ದಾರೆ.
All right.
1 lakh.
1,90,000 is awarded, same is retained. Attendant charges, food, conveyance.
9 days inpatient, my lord.
Huh?
9 days inpatient.
30,000 is awarded, same is retained. Medical expenses of 1,94,390 is retained. Future amenities is awarded, loss of future amenities is awarded at 75,000, same is retained.
Another 25,000 maybe.
Towards future medical expenses, tribunal is not awarded any amount. Considering the injuries sustained, this court is of the opinion 15,000 would be a reasonable amount to be awarded. Hence, 15,000 is awarded under this head. Stop. In view of the above discussions, the claimant would be entitled to total compensation of rupees 12,98,190 as against 7,59,400. Accordingly, I pass the following order. Appeal is allowed in part. Judgment is modified. Claimants entitled to total of compensation of 12,98,190 along with interest at 6% per annum. The balance compensation shall be paid within a period of
6 weeks, my lord, copy of
6
that.
weeks from the date of receipt of copy of the order shall be deposited before the jurisdictional tribunal. The same shall be dispersed in favor of the claimant upon the claimant furnishing necessary bank details in accordance to the terms and conditions stipulated by the order of the tribunal. The trial court record shall be transmitted to the jurisdictional tribunal forthwith.
Much obliged, my lord.
Serial number 65, Mulats.
Yes,
This is an appeal filed by the insurance company, challenging our quantum of compensation awarded.
or learned counsel issue notice to respondents. That shall be stay of operation and execution of the judgment award dated 6/3/24 in MVC 449 of 2018, passed by Senior Civil Judge JMFC at Mudigeri. Subject to the condition the appellant deposits 50% of the award amount within a period of 4 weeks from today before the
Tribunal, Mulats.
jurisdictional tribunal, which shall be kept in a fixed deposit for a period of 6 months.
This is an appeal, filed by the insurance company. Although we are the insurer of the vehicle, we have issued only a standalone own damage policy. Third party policy is issued by a different company, which company has not been made a party, but liability has been fixed on me. Although third party risk is not covered under my policy. Case of injury,
All right. Worked. So you are the insurer of whom?
of the liability is fixed on both the vehicles. However, I have issued only a standalone OD policy. May recollect, the apex court in one of the decisions had said that two-wheelers will have 5 years third party policy and cars will have 3 years third party policy at the time of selling the vehicle. So what the owner does is he gets a standalone OD policy from a different company. I am that insurer who has given only the OD policy.
What is OD policy?
Own damage policy, Mulats. Third party
damage.
risk is covered by ICICI Lombard in this particular matter.
They are not made party?
They are not made party, Mulats, despite taking specific defense.
So what's the liability fixed on you?
Liability has been fixed on me, Mulats. 50%. 50% of the award amount has to be paid by me.
You are for which insurance company?
Royal Sundaram, Mulats.
That is the third respondent, fourth respondent.
Please, Mulats.
%50%. Heard. Third counsel issue notice to respondents. There shall be stay of operation and execution of the judgment and award dated 3/4/24 in MVC 3154 of 2022, passed by the Additional Judge Court of Small Causes and MACT at Bengaluru City with respect to the share of the appellant herein. Subject to the condition, the appellant deposits 50% of his share before the jurisdictional tribunal within 4 weeks from today.
Much obliged.
ಏನಾಗಿದೆ ಇದರಲ್ಲಿ? ರಿಪೋರ್ಟ್ ಬಂದಿದ್ಯಾ?
Report, not yet been,
Huh?
not yet income.
Not yet come. You have not collected the check?
Was the first respondent,
Who had given the check?
first respondent, first respondent.
You. You are appearing for whom?
I appeal for the first.
You have not collected the check.
No, Lord, I have come on record of late, I'll verify.
No, that becomes now, I think, time barred ಆಗಿರಬೇಕದು.
No.
He has deposited check for you to be withdrawn. is it?
That is a check in favor of the thing.
What was the purpose of directing the commissioner to inspect?
And regarding the encroachment portion has to be identified in both the respect of B schedule property and A schedule property. Where the declaration is given in respect of the A schedule property, B schedule
So
property.
commissioner, you have participated, he has conducted or not conducted?
Not yet been conducted
They
the,
have conducted, my lord. I appeal for the.
Order sheet
for the UA to see, the commissioner has inspected the spot and conducted the survey, but not submitted the report.
So commissioner has conducted the survey
Yes, ma'am.
without intimating. You are not intimated.
So they
Intimate.
also participated in the.
Participated.
Yes.
All parties. So report is to be filed. Who was the commissioner appointed?
ADLR.
DLR, there from Bangalore East.
All right, then we'll await commissioner's report. Await commissioner's report. Relist on. ಎರಡು ವಾರ, ಒಂದು ವಾರ.
Any date may be specified or issued.
Date, we are fixing date now. All cases. When do you want, Badri?
Any Friday.
Yes, Mr. Sure. Any Friday you want? Okay, Friday auspicious idea.
No, not like that.
Friday combination of benches ಬರುತ್ತೆ ಅದಕ್ಕೆ. No, you want Friday, I'll give it on Friday. 23rd?
Yes.
Great.
Let the, or rather, registry may be direct to issue reminder to the commissioner report.
Lord, office may be directed to send a reminder to the.
Registry. To send a reminder. To the commissioner. It is ADLR, details ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. ಅಲ್ಲಿದೆ, order ಅಲ್ಲಿದೆ. To furnish the report by the next date of hearing.
Great.
Yes.
This is the appeal preferred by the case at Simela on the ground both on quantum and the negligence aspect.
Both of you have filed appeal.
ಅವರು
My
ಕೌಂಟರ್
appeal is
ಹಾಕಿದ್ದಾರೆ.
enhancement of.
Hmm?
Enhancement of compensation.
Both of you have filed appeal.
Please.
One by the claimant, one by corporation.
Yes.
Please.
I have preferred appeal based on the grounds, my lord. But deceased also contributed to the accident because he chose to cross the highway where there was no zebra crossing.
Where there was no
Zebra crossing. Zebra,
Zebra
pedestrian crossing.
zebra crossing.
Yes, ma'am.
He was walking.
Yes, he crossed the road
Okay.
where he is supposed to not to cross the road on the highway, national highway.
Pedestrian.
Yes, ma'am.
Kamata Mari Kunte village.
Yes, ma'am.
NH 150. All right.
And
Yes.
second round is, his age is at dispute, my lord.
Hmm.
The postmortem report says that he's 56, but the records where I have produced along with my appeal, my lord, it says that he's aged about 67, my lord. I have produced the Aadhaar card along with my appeal.
Aadhaar card and ration card.
Yes, ma'am. Where it clearly depicts that his age is, he was born on 1948.
Hmm.
So the tribunal has failed to take all these.
What's the date of accident?
This is of the year, my lord.
Accident.
30, yes, madam.
27.
2/7/2018 at 8:40 AM.
27/18.
Yes, madam.
So what will be the age? 48.
He has crossed 70, madam. So multiplier should be 5.
Yes, cross 70.
Yes, madam. Because the ration card depicts that at the year 2012, he was 65.
Ration card.
Yes, ma'am. 2012, date of issuance. By that time, he was 65.
Really they are age.
In both the records, the age date of birth is 1/1/1948.
Ration card ಅಲ್ಲಿ age ಎಲ್ಲಿದೆ?
ಇದೆ ಸ್ವಾಮಿ, ರಾಮಣ್ಣ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ 65 ಅಂತ ಇದೆ.
ರಾಮಣ್ಣ.
Bracket ಅಲ್ಲಿ 65. Issuance is below that same document ಅಲ್ಲಿ issuance date 38/2012.
I'm unable to see it.
ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ, ಕೆಳಗಡೆಗೆ ಬಂದ್ರೆ ರಾಮಣ್ಣ ಅನ್ನೋದ್ರ ಕೆಳಗಡೆ ಬಂದ್ರೆ,
ರಾಮಣ್ಣ.
ಹಂಗೆ ಕೆಳಗಡೆ ಬಂದ್ರೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಅದೇ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಕೆಳಗಡೆಗೆ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ.
Issuance date.
Yes, madam.
ಅದು issuance date, but where?
38/2012 ಗೆನೆ 65 ಆಗಿತ್ತು ಅವ್ರಿಗೆ.
ಎಲ್ಲಿದೆ ಅಲ್ಲಿ 65 ಅಂತ ಎಲ್ಲಿದೆ ಏಜ್?
ರಾಮಣ್ಣ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ 65 ಅಂತ ಹಾಕಿದ್ದಾರೆ. That is the age.
Okay. Yes, 65.
So he has crossed 70, my lord, the date of accident.
So 22 will be 75. So this happened minus 4. So he is more than 70.
Yes. So 5 should be the multiplier.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
ಅವ್ರು 9 ಏನೋ ತಗೊಂಡಿದ್ದಾರೆ. Because PM report says that 56 ಅಂತ ಹೇಳ್ತಾರೆ.
Tribunal, my lord, after considering the PM report, my lord.
Let us finish, after that you can.
Yes, my lord. Next point is, my lord.
Which paragraph is that age taken, madam?
My lord. It is at page 17. Under such circumstances, exhibit P7 PM report.
Para
where
22.
Yes, madam. 23.
23
nalli mentioned as 56 years.
50, he was only 55 years. 68 years, but PM report says 50 years. Disputed, PM report 56 years. So multiplier is taken at a 9.
Yes. Because PM report prakara 9
is
has to come down to 5.
Multiplier will be taken at 5.
ಇವಾಗ ತಗೊಳ್ಬೇಕಾಗಿರೋದು 5. Tribunal has taken 9 based upon the PM report's age. First point is contributory negligence is 50% has to be deducted, my lord. Second is age. Third one is
How contributory negligence?
because
of
he chose to
crossing.
cross the national highway
Whether
where he was
tribunal
not
is
supposed to.
Held any contributory negligence or?
No, it has not at all considered my point. Because moreover, they have failed to examine the eyewitness. They have examined only one witness, that is the deceased wife.
So contributory negligence ಎಷ್ಟಾಗಬೇಕು?
ನನ್ನ ಪ್ರಕಾರ 50% ತಗೊಳ್ಬೇಕು.
All right. So it was national highway or state highway?
National highway. Exhibit P4 is the sketch, my lord.
Yes. This sketch ಇದೆಯಮ್ಮ madam, file is
Highway, ಇದೆ.
records. Admission ಅಲ್ಲಿ ಇದೆಯೇನು ಇದು?
ಇದು certified copy ಇದೆ ಸ್ವಾಮಿ. ನೋಡ್ತೀರಾ?
You have?
I have got certified copy.
It's in the center of the road.
Not, my lord. A blood stain marks 6 feet edge ಅಲ್ಲಿ ಇದೆ. Accident spot.
So accident spot is at the
Service
After
road.
6 feet footpath ಆದ್ಮೇಲೆ 4 ಅಡಿ ಆದ್ಮೇಲೆ.
is on the NH 15. All right. Yes.
ಅಲ್ಲಿ ಎಲ್ಲೂ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ.
ಅಪಘಾತ ಸ್ಥಳ ಅಂತ ಎಲ್ಲೂ ಬಂದಿಲ್ಲ.
ಪೆಡೆಸ್ಟ್ರೈನ್ ಕ್ರಾಸಿಂಗ್ ಎಲ್ಲೂ ತೋರಿಸಿಲ್ಲ ಸ್ವಾಮಿ.
All right. Predict. Yes.
And in fact, I have posed questions for the petitioner one to produce the relevant documents to prove the age factor, my lord. They admit to produce, but they have failed to produce the same.
You filed what application?
In fact, we have posed question during the time of cross-examination, so they admit to produce the same, but somehow they have not produced.
All right.
So that's why I am forced to file at the time of appeal, my lord,
Okay.
as an additional document. Next ground is, my lord.
So you had those documents then?
I have posed question saying that this is
You
the.
should have confronted this
No, my
document.
lord. By that time, I have not procured, because she admits that she is going to produce the same records in the cross-examination.
All right, in the cross-examination.
Yes, my lord.
But after that, in your evidence or.
ಮಾಡ್ಬೇಕಿತ್ತು ಅವ್ರು ತಗೊಂಡ್ ಬರೋ ಅಷ್ಟೊತ್ತಿಗೆ ಜಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್.
Okay.
Next question, my lord. Next ground is, my lord.
Hmm.
Dependency.
Hmm.
She admits that all her kids are not dependent on them. They have married and separated, they have stayed separately.
Hmm.
In the examination itself, she has admitted only both husband and wife are staying together.
Hmm.
So my contention is that 50% dependency has to be taken.
It's because the children are all.
All are independent and got married. She herself admits in the examination.
Yaro.
Cross-exam, wife.
All right. Deceased wife.
Yes.
PW1 Girijamma. All right, but he's married. How can 50% be taken?
Yes.
All right.
Both the 3 kids have been already married and are started staying separately,
Hmm.
independently, my lord.
Yes.
He admits very clearly in the cross-examination. And apart from that, 9% interest has been taken by the tribunal, which is not correct, my lord. Because during at the time of, I think, COVID season ಅಲ್ಲಿ 9% ಅವಾಗ KSRTC ತುಂಬಾ ಲಾಸ್ ಅಲ್ಲೇ ನಡೀತಾ ಇತ್ತು. That is also exorbitant interest.
That's all.
These are all the grounds, my lord.
Okay. Next.
My lord, with regard to the negligence, my lord, after thorough investigation, the police have filed the charge sheet against driver of bus, KSRTC bus, my lord. Driver of KSRTC bus not examined before the tribunal with regard to the negligence of the deceased. My lord, may I read the charge sheet, my lord?
For what?
For my lord, with regard to the negligence.
No, that KSRTC bus driver has been implicated in the criminal case.
Please.
He has pleaded guilty.
Pleaded guilty about 304 NL pleaded, not pleaded guilty. They are contesting.
What happened to that?
ಅದು ಗೊತ್ತಿಲ್ಲ ಅದು ಏನಾಗಿದೆ ಅಂತ.
Police documents are not the primary
All
documents
right,
to come to
that is not in
conclusion.
dispute now.
Please.
Criminal case is not in dispute.
Yes.
What she's arguing is that you also would have contributed because you should have. There was no
Chosen to
zebra
cross.
crossing.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇನ್ನು ದಾಟುತ್ತಿದ್ದ ಅಂತ ಬಂದಿದೆ. ಮಿಡ್ಲ್ ಆಫ್ ದಿ ರೋಡ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದ ಅಂತ ಏನು ಎಲ್ಲೂ ಇಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಈತನು KSRTC ಬಸ್ ಚಾಲಕನಾಗಿದ್ದು ಹಿರಿಯೂರು ಕಡೆಯಿಂದ ಅತಿವೇಗವಾಗಿ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ಕಮ್ಮತ್ ಮರಿಕುಂಟೆ ಗೇಟ್ ಕಡೆಯಿಂದ ಗೋಪನಹಳ್ಳಿ ಕಡೆಗೆ ಹೋಗಲು ರಸ್ತೆಯನ್ನು ದಾಟುತ್ತಿದ್ದ ರಾಮಣ್ಣ ಅಲಿಯಾಸ್ ರಾಮಯ್ಯ ಇವರಿಗೆ ಬಸ್ಸನ್ನು ಡಿಕ್ಕಿ ಹೊಡೆಸಿದ ಪರಿಣಾಮ ರಾಮಣ್ಣನವರು ರಸ್ತೆಯ ಮೇಲೆ ಬಿದ್ದು ಅವರ ತಲೆ ಮತ್ತು ಕೈ ಕಾಲುಗಳಿಗೆ ಬಲವಾದ ಪೆಟ್ಟುಗಳು ಬಿದ್ದು ರಕ್ತಗಾಯಗಳಾಗಿ ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತಪಟ್ಟಿರುತ್ತಾನೆ. This is the, my lord, investigation, my lord, the police have filed the charge sheet against the.
Sketch is also marked.
Mark agi.
You're not denying that.
My lord,
You're not denying that.
no.
So accident has happened, he has died, he was
Please.
crossing the road.
Yeah, admit that.
He was crossing the road.
Crossing the middle of the road ಅಲ್ಲಿ ಆಗಿಲ್ಲ.
Middle ಆಗ್ಲಿಲ್ಲ, side ಎಲ್ಲ
Auto
ಆಗಿದೆಯಲ್ಲ. Side ಎಲ್ಲ ಆಗಿದೆಯಾ ಇಲ್ವಾ?
ನೋಡಿ ಸ್ವಾಮಿ.
Correct, sir. You have to tell
6
me,
feet.
he is not on the footpath. He is in the road. It may not be in the middle of the road. If it was not in the middle of the road or in the side of the road, it is not your case that the bus has gone on, jumped to the footpath and hit him. Is it your case?
No.
Mate? You are in the road, whether little portion, 1/4 portion, whatever portion. You are trying to cross the road. ಅಲ್ಲಿ ಬಂದು ಹೊಡೆದಿದ್ದಾರೆ.
The driver of the KSRTC bus, my lord, very much conscious and driving the vehicle, my lord, crossing the pedestrians.
So what the tribunal has done, entire liability is,
Posed on the
Please.
case.
so contributory negligence was pleaded by you or not?
Yes, it was
No.
pleaded. We have led evidence saying that there is no fault.
ಇಲ್ಲ ಎವಿಡೆನ್ಸ್ ಮಾಡೇ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದು
ಮಾಡಿದ್ದೀವಿ, driver evidence ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿಲ್ಲ.
So why you did not adduce evidence?
ಅವ್ರ ಐ ವಿಟ್ನೆಸ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದಾರ?
ಅವ್ರ ಐ
You
ವಿಟ್ನೆಸ್
have not examined any.
ಅವ್ರದ್ದು ಯಾರು ವಿಟ್ನೆಸ್ ಇಲ್ಲ, only one lady, that wife.
ನಾವು ನಮ್ದು
Chief of the DC.
ನಮ್ಮ ಡ್ರೈವರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀವಿ ನಾವು.
ಎಲ್ಲ ಮಾಡಿದ್ದೀರಾ?
Yes, it is there. Ashok ಅಂತ. Even in the annexures of the judgment,
Correct.
it is
yes,
clearly
one
depicted.
Ashok. What has he said?
Says
Read it,
my
sir.
law. ನಾನು ಎದುರುದಾರ ಕಾರ್ಪೊರೇಷನ್ ಡ್ರೈವರ್ ಆಗಿ ಸೋನ್ಸೋ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಬಸ್ಸಿನ ಚಾಲಕನಾಗಿ ಚಳ್ಳಕೆರೆಗೆ ಹೋಗುತ್ತಿರುವಾಗ ಸದರಿ ವಾಹನ ಸಾಧಾರಣ ವೇಗದಲ್ಲಿ ರಸ್ತೆಯ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದಾಗ ಸಡನ್ ಆಗಿ ಮೃತ ರಾಮಣ್ಣ ನಮ್ಮ ವಾಹನಕ್ಕೆ ಅಡ್ಡ ಬಂದಿದ್ದರಿಂದ ಸದರಿ ವಾಹನವನ್ನು ಅಪಘಾತ ತಪ್ಪಿಸಲು ಎಷ್ಟೇ ಎಡಭಾಗಕ್ಕೆ ತೆಗೆದುಕೊಂಡರೂ ಸಹ ಸದರಿ ವಾಹನವು ಮೃತನಿಗೆ ಡಿಕ್ಕಿಯಾಗಿ ಅಪಘಾತ ಉಂಟಾಗಿರುತ್ತದೆ. ಈ ಅಪಘಾತಕ್ಕೆ ಮೃತನ ಹೆಚ್ಚಿನ ಅಜಾಗರೂಕತೆ ಮತ್ತೆ ನಿರ್ಲಕ್ಷ್ಯತೆಯು ಕಾರಣವಾಗಿರುತ್ತದೆ. ನಮ್ಮ ಸಂಸ್ಥೆಯವರು ಯಾವುದೇ ಬಾಧ್ಯತೆಯನ್ನು ಒಪ್ಪಿಕೊಳ್ಳದೆ ಅರ್ಜಿದಾರರಿಗೆ ತಕ್ಷಣ ಪರಿಹಾರವಾಗಿ 15,000 ರೂಗಳನ್ನು ನೋಡಿದೆ. ಇದೊಂದು ಪಾಯಿಂಟ್ ಮಿಸ್ ಆಗಿತ್ತು. 15,000 ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೇವೆ. ಒಂದು ವೇಳೆ ಘನ ನ್ಯಾಯಾಲಯ ಅರ್ಜಿದಾರರಿಗೆ ಪರಿಹಾರ ಘೋಷಣೆ ಮಾಡಿದ್ದರೆ ಮೇಲ್ಕಂಡ 15,000 ರೂಗಳನ್ನು ಒಟ್ಟು ಪರಿಹಾರ ಮೊತ್ತದಲ್ಲಿ ಕಡಿತಗೊಳಿಸಲು ಎದುರುದಾರರ ಪರ ಕೇಳಿಕೊಂಡಿದ್ದೇನೆ. ಅಪಘಾತ ಸಮಯಕ್ಕೆ ಮೃತರಿಗೆ ಸುಮಾರು 70 ವರ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ವಯಸ್ಸಾಗಿದ್ದು ನಮ್ಮ ನಿಗಮದಿಂದ ಹೆಚ್ಚಿನ ಪರಿಹಾರ ಪಡೆಯುವ ಉದ್ದೇಶದಿಂದ ಮೃತರಿಗೆ ಅಪಘಾತ ಸಮಯದಲ್ಲಿ ಕಡಿಮೆ 56 ವರ್ಷ ವಯಸ್ಸಾಗಿರುವುದರಿಗೆ ಬರೆಸಿರುತ್ತಾರೆ. ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ನ್ಯಾಯಾಲಯವು ಅವುಗಳನ್ನು ಎದುರುದಾರ ಪರ ನಿಷೇಧವಾಗಿ ಗುರುತಿಸಲು ಪ್ರಾರ್ಥನೆ. ದಿಸ್ ಈಸ್ ಮೈ ಎವಿಡೆನ್ಸ್ ಬಿಫೋರ್ ದಿ ಮ್ಯಾಟ್.
Yes. Yes, what else?
Lord,
You are seeking enhancement on what grounds?
Enhancement, my lord, date of accident is 2/7/2018. Lord, income considered 10,500 before the tribunal. Lord, according to the chart, my lord, 12,500 is the income.
Actually, he was aged about 70. Half of the income has to be considered.
So 12,500 ತಗೊಳ್ಬೇಕಾ?
Please. Age ಬಗ್ಗೆ, my lord, during the course of cross examination. ನನ್ನ ಗಂಡ ನನಗಿಂತಲೂ 2-3 ವರ್ಷ ದೊಡ್ಡವನು ಇರಬಹುದು. ಆಧಾರ್ ಕಾರ್ಡ್ ನಿಶಾನೆ P11 ಪ್ರಕಾರ ನನ್ನ ವಯಸ್ಸು 66 ವರ್ಷ ಆಗಿದೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ಗಂಡ ತೀರಿಕೊಳ್ಳುವ ಕಾಲಕ್ಕೆ 70 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಹೆಚ್ಚಿನ ಪರಿಹಾರ ಪಡೆಯುವ ಸಲುವಾಗಿ PM ರಿಪೋರ್ಟ್ನಲ್ಲಿ ಅವನಿಗೆ 56 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು ಎಂದು ಸುಳ್ಳು ಬರೆಸಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ರೇಷನ್ ಕಾರ್ಡ್ ಹಾಜರುಪಡಿಸಿದಲ್ಲಿ ಸತ್ಯ ವಿಚಾರ ಬರಬಹುದೆಂದು ಪರಿಹಾರ ಕಡಿಮೆ ಬರುತ್ತದೆ ಎನ್ನುವ ಕಾರಣಕ್ಕಾಗಿ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿಯೇ ರೇಷನ್ ಕಾರ್ಡ್ ಅನ್ನು ನಾನು ಹಾಜರುಪಡಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಗಂಡನಿಗೆ ಆಧಾರ್ ಕಾರ್ಡ್ ಇದ್ದು ನನ್ನ ಗಂಡನಿಗೆ ಆಧಾರ್ ಕಾರ್ಡ್ ನಂಬರ್ ಸೋ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಆಧಾರ್ ಕಾರ್ಡ್ನ ಪ್ರಕಾರ ನನ್ನ ಗಂಡನ ಜನ್ಮ ದಿನಾಂಕ 1/1/1948 ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಗಂಡನಿಗೆ 70 ವರ್ಷಕ್ಕಿಂತಲೂ ಹೆಚ್ಚು ವಯಸ್ಸಾಗಿದ್ದರೂ ಕೂಡ ಅವನಿಗೆ 56 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು ಎಂದು ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಸುಳ್ಳು ಸಾಕ್ಷ್ಯ ನುಡಿಯುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. Totally, my lord, they have denied the entire cross examination of it.
He has now produced. He has now produced.
Please.
That has to be taken. Have you filed objections to that?
No.
Are you denying it? It's your own document. We'll go by that age only.
Please.
Anything else? Income.
With regard to the deduction, my lord, 1/3.
What the tribunal has done?
Tribunal, my lord, 1/3 has been taken. Personal and living expenses.
ಇನ್ಕಮ್ 6,067 ತಗೊಂಡಿದ್ದಾರೆ. ನನ್ನ ಪ್ರಕಾರ ಅದು
1/3.
50% ಆಫ್ ದಿ
Future prospects 10% ತಗೊಂಡಿದ್ದಾರೆ. ಈಗ
70 ವರ್ಷಕ್ಕೆ future
70 years ಬರದ more than 60 years ಆದ್ರೆ future prospects.
ಬರೋದಿಲ್ಲ,
Future prospect ಇದರಲ್ಲಿ ಏನ್ ಬರಲ್ಲ.
ಬರೋದೇ ಇಲ್ಲ.
Only income 12,500 can be taken.
12,500 ನನ್ನ ಸಬ್ಮಿಷನ್ ಬಿಕಾಸ್ he crossed 70. It should be 50%.
But where is which law?
ಅದೆಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ ಲೀಗಲ್ ಇದರಲ್ಲಿ. ಬಟ್ ಜನರಲ್ ಇದರಲ್ಲಿ ಯಾಕಂದ್ರೆ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ದವರು ರಿಟೈರ್ಡ್ ಆದ್ರೆ 50% ಆಫ್ ದಿ ಸ್ಯಾಲರಿ.
But what was he doing?
Was no,
My lord, he was
not been
doing
proved, my lord.
a fruit vendor. Notional income may be according to the chart.
But I don't think any court has held that if you are more than 70
Not-
years,
Does not
income
help.
should be
Of
taken
course,
half.
Just
half.
as a principle of law, I would like to make such submission.
Good submission.
Yes, my lord. No
Should be
court was held.
considered.
Yes, my lord.
Yes, that's all.
And 15,000 has to be deducted.
15?
15,000 ಕೊಟ್ಟಿದ್ದೀವಿ ex
Interim
gratia.
payment which you.
Yes, and 9% interest has to be reduced.
Record. These two appeals are preferred. Challenging the judgment and award. Dated 30th March 21. In MVC 405 of 19. Passed by Senior Civil Judge and Additional MACT Chalakere. Full stop. The appeal preferred by the claimant is seeking for enhancement of compensation on the ground of inadequate compensation awarded, whereas appeal preferred by the insurance corporation is to set aside the judgment and award as the same being erroneous, arbitrary, and illegal. Full stop. Party shall be referred to as per status before the tribunal. On appreciation of the materials placed on record, the tribunal has awarded total compensation of 10,27,039 rupees with interest at 9% per annum. Directed respondent number 1 and 2 to deposit the compensation within 1 month from the date of the order. Stop. It's the vehement contention of learned counsel for the claimant that the tribunal has committed an error and illegality in not taking into consideration the materials placed on record, both oral and documentary. Tribunal has failed to assess proper income for computation of compensation. So also tribunal has awarded meager compensation on other heads, which requires an enhancement. Accordingly, he seeks to allow his appeal. Full stop. Para. Per contra, learned counsel representing the corporation vehemently contends that the tribunal has committed a gross error in awarding exorbitant compensation without taking into consideration the materials placed on record, both oral and documentary, and so also the evidence adduced by the parties. Full stop. See further contents that the tribunal has failed to take into consideration the contributory negligence of the deceased himself while crossing the road. He has not bothered to take precaution, and it is because of his negligence the accident occurred. She further contends that the tribunal has committed an error in deducting 1/3 towards personal and living expense. Whereas it should have been 50% as the other, as the claimants are dependents. As the claimants are not dependent on the deceased. They were all major, married and well settled. Thirdly, she contends that the interest component awarded is exorbitantly high. The same requires to be drastically reduced. It is also contended that as an interim measure, an ex gratia payment was made of rupees 15,000, which requires to be deducted from the compensation. On these grounds, he seeks to allow the appeal referred by the corporation. Consequently, reduce the compensation. Having heard learned counsel for both parties, the occurrence of the accident, involvement of the vehicle, death having occurred due to the accident, though disputed, has been proved and established by production of exhibits P1 to P12. Negligence is rightly attributed against the driver of the KSRTC bus. Now, we'll stop. Para. Coming to the question of age, avocation, income, and the multiplier to be adopted. At the time of recording of evidence, it is seen that the claimant has stated that the deceased was aged between 55 to 60 years. In fact, the postmortem report at exhibit P7 mentions 50 years. Taking the same into consideration, tribunal has arrived at the age of 56 years and applied the multiplier of 9. Whereas learned counsel for the corporation has filed an application under Order 41, Rule 27 by producing copy of the Aadhaar card as well as the ration card belonging to the deceased, which clearly depicts that the deceased was aged around 70 years, correct?
Yes.
70 years ago.
Date of birth is 1/1/1948.
So he was aged around 70 years. So therefore, the question of taking the multiplier at 9 may not arise. The multiplier would have to be taken at 5.
5.
The income is taken as 10,000 per month, whereas the Legal Services Authority chart for the year 2018 describes 12,500. And in the absence of any proof of income, 12,500 requires to be taken as the notional income. Accordingly, it is taken. In view of the above, the loss of dependency would be 12,500 into 12 into 5, please.
5.
7,50,000.
1/3
Deduction are with
1/3.
12,500 divided by 3, 4,166. 8,234 into 12 into 5. Huh? 5,40,000. 5,40,000 would be the loss of dependency, as against 7,20,036 rupees. Future prospects ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅಲ್ಲ ಅದು including ಅದನ್ನು ಸೇರ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ.
ಇಲ್ಲ ಸಪರೇಟ್ ಹೆಡ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
Separate
ಕಲಿಬೇಕು.
ಹೌದು.
What basis future prospect is?
10% add ಮಾಡಿದಾರಲ್ಲ.
10%.
Please.
For that they are not.
I'm in agreement with learned counsel for the corporation that the question of awarding future prospect in this case would not arise. So awarding of 10% future prospects by the tribunal is erroneous, same is set aside.
$10%. 4.
Yaro? 4 all?
4 members.
4 members. There are 4 persons who claim to be the dependents of deceased Ramana. Though they may not be entitled to loss of dependency, they would be entitled to loss of estate. Under the circumstances, each one of them would be entitled to 40,000 per person as contemplated in the case of Pranay Sethi. 40,000 into 4, 1,60,000 is awarded under this head. What is this loss of status?
That's also. on-
Estate,
Yes. Estate
loss of
status.
estate another loss of state.
60,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು,
That's wrong.
ಅಲ್ಲಿ
That's also
15,000.
wrong.
15,000
Towards
ಮತ್ತೆ
the loss
funeral
of
15,000.
estate and loss of funeral expense. 15,000 each is awarded, totaling to 30,000
Not 10% extra.
with a 10% escalation. 33,000 is awarded. Towards a consortium. 10% escalation. Would be plus additional 16,000. Therefore, in all, the claimants would be entitled to total compensation of 7,09,040
Minus 15,000.
rupees. Para. The corporation has paid ex gratia amount as a added interim measure, as an interim measure of 15,000, which would have to be deducted from the total amount. So 7,09,040 minus 15. $6,94,040. Full stop. Para. It is, I'm in agreement with learned counsel for the corporation that the deceased while crossing the road has not taken proper care and caution. Though the FIR and charge sheet is laid against the driver of the bus, some amount of contribution is contributory negligence has to be fastened on the deceased himself for not taking proper care and caution while crossing the road, which is a national highway. Under the circumstances, this court is of the opinion that 10% contributory negligence has to be fastened.
To place reliance on some judgments where 25% has been reduced.
There's discretionary, which is that judgment? What is the facts of that case?
Same facts.
Our appeal
Where
memo,
they have not chose to
My lord.
cross the road on zebra cross.
10% contributory negligence is fastened on the deceased. Full stop. I'm also in agreement with the learned counsel for corporation that the interest component awarded is on the higher side. Same will have to be reduced to 6%. In view of the above discussions, pass the following order. The appeals are disposed, judgment and award is modified. Claimant are entitled to total compensation of rupees 24 or 94? 6,24,636 as against 10,27,039.
Calculation. 10% reduce other 5,90,000.
I think a master card,
10% reduce.
6 lakh. What is? 6,94,000?
40.
040. Minus 69,404.
$69,000.
6,24,000, correct?
Yes. Okay.
6,24,636.
I may be permitted to produce these two, sir. Sorry, my lord.
Judgment.
25% has to be deducted while they choose to cross the highway.
What
my submission towards the consideration of income for who person cross the age of 60, that may be noted. Madam. As per the KCCR rules, one who crossed the 60 years are eligible for 50% of this.
Yes, you have a copy?
I have one copy.
Read what you want to read.
No, at page 9 in MFA number 6199 of 2019. At page 9. Therefore, it is very clear that the driver of the bus was negligent is causing the accident. We further contend that it is also very clear from the Mahazar complaint IMB report, the driver bus was alone was negligent in causing the accident. The tribunal has erred in holding that the deceased was contributed 25% of that. Secondly, in respect of the, I'm sorry, my lord. Para 5. Think,
Page 12 ಅಲ್ಲಿ ಇದೆ. The driver of the bus was proceeding.
Not having that copy. I'm having some different copy.
ಅದೇ judgment ಅಲ್ಲಿ page 12
Yes, madam.
driver of the bus ಅಂತ
The
ಇದೆಯಾ?
driver of the bus was proceeding with high speed and in a rash and negligent manner, and he has also not made any effort to control the bus. Therefore, the tribunal is justified in holding that the driver was contributed to an extent of 75% to the accident, and the deceased was contributed to an extent of 25% to the accident. Therefore, in all along, in all the cases where the person who choose to cross the national highway will be fixed liability to the extent of 25%, my lord.
So next judgment is a
Next
division
judgment
bench.
also confirm the same.
All right. That court is relied on this bench. This is in 22, this is in 20. Okay. All right, ಬರ್ಕೊಳ್ಳಿ. 25%.
My lord, I will bring a judgment, my lord. My lord.
You should have brought, can't be now after relying, I can't keep on moving like that.
My lord, Monday, my lord,
Bench judgment.
I will give a division bench judgment, my lord, entire negligence, my lord, while crossing the road, my lord, shifting the KSRTC bus only, my lord.
Why did you commence your argument today, Mr. Rangaragoda? After she has relied on the five finished dictating, you are submitting. Nothing stopped you from producing when she argued.
Kindly, my lord, Monday.
Now, how can I differ from the division bench judgment of this court?
I am relying on very same division bench, my lord, decision. I will bring, my lord.
No, you are late. How can I now wait for you? I have already dictated the judgment. You should have come ready with the case laws. Sir, division bench judgment of this court.
Adರಲ್ಲಿ the very same advocate is representing, my lord. Sorry, I will not bring the judgment.
I may make that instead of 10%, 25% contributory negligence, wherever you said. Accordingly, calculate the difference. Good. Learned counsel for the corporation relies on the following two judgments in support of her case. In the case of MFA 6199 of 19 connected with 6728 of 21 and division bench judgment of this court in MFA 3004 of 19 connected with 5589 of 19. Whereby in similar situation, a pedestrian crossing the national highway, the courts have held 25% to be contributory negligence. As a matter of judicial discipline, this court is bound to follow when similar issues are related to crossing by a pedestrian of the national highway. Hence, I am in agreement with learned counsel for the corporation. All right. Do that calculation, 25%. Instead of 10%, it will be 25%. Accordingly, appeals are disposed, claimant is entitled to so and so. So you have deposited only 50%. You have deposited 50%.
Yes,
The balance you have to
balance
deposit.
I have to take back.
Balance amount shall be deposited for the trial court within a period of 4 weeks from the date of receipt of copy of the order. No excess amount is deposited.
Excess amount is, my side is more than.
You have deposited more.
Excess amount.
Yes, to
50%.
no, the amount itself is
Along
10.
with the interest, 9% interest calculate ಮಾಡಿ ಹಾಕಿರ್ತೀವಿ.
All right. In
If
case
any
of,
excess amount is there, I'm
case of
permitted
excess
to-
amount having been deposited by the corporation, the same shall be refunded. If they are withdrawn,
No, no, order has not been passed.
the same shall be refunded to the corporation upon proper identification.
Obliged.
Claimant appeal for enhancement, my lord.
Case opposing you, madam, again. You are ready in this case? Injury case.
Case of injury, my lord. 6/1/2007, 6/11/2017 accident, my lord. Aged about 66 years.
Aged about?
66 years.
Ah.
She was a coolie, working as coolie. 15,000 per month earnings, my lord. Sustained injury, my lord. Page number 8, para 11. She sustained undisplaced fracture patella with vertical fracture of anterior sacrum is noted at S3, S4, S5 vertebral level fracture, left distal sacral ala and head injury. But as per PW3, doctor stated that, my lord, disability, my lord, 38% right lower limb and 12% whole body disability, my lord. The triple is considered, my lord, only 10% disability, my lord. Income is considered, my lord, only 7,000, my lord.
Where is the evidence of doctor?
PW3, my lord.
38%.
38% right lower limb and 12% whole body disability, my lord. The triple is taken only 10%.
10%.
Whole body disability. Income is considered, my lord, 7,000, my lord. Lord, she was
Age 66 years, huh?
66 years, my lord. She was admitted in hospital 12 days, my lord. Pain and suffering is awarded, my lord, 30,000, loss of amenities 20,000, loss of earning laid up period was 14,000, and future loss of earnings, my lord, 42,000, total 1,09,000 along with 9% interest, my lord. Well, 2017 accident, my lord, as per chart, my lord, 11,000 rupees, my lord. Disability, my lord, whole body 12,000 instead of 10,000, 12% interest of 10%, my lord. And further, my lord, pain and suffering 30,000 is lower side, my lord. And incidental attendance
conveyance, there is no amount in awarded, my lord. ಕೊಟ್ಟಿಲ್ಲ ಏನು.
ಯಾವ್ದಕ್ಕೆ?
Incidental, conveyance, enhancement, food, attendance charges.
Food, attendant, conveyance, nourishment, 3,600 ಕೊಟ್ಟಿದಾರಲ್ಲ. Incidental charges. You are inpatient for 12 days.
12 days, my lord.
Which accident is of the year 17.
17.
All right.
And my lord, loss of earning laid off period. 2 months is taken, my lord, 7,000 rupees, 14,000 rupees awarded, my lord. And future earnings, yes, all at my lords.
All right. Anything else?
Yes, my lord.
That's all.
That's all.
Yes.
Thanks, sir. Submission, my lord. The doctor says that whole person disability 12%.
Huh?
12% whole body disability anta kottidare evidence. Only thing the trial court has made some guesswork because of the age factor. It has reduced to 10% disability. They have taken it. And of course, 7,000 ತಗೊಂಡ್ರು ಕಡಿಮೆ. But those are all.
11,000 ತಗೊಂಡು dispose ಮಾಡ್ಬೋದು. Record. This appeal is preferred by the claimant, challenging the judgment and award dated 20th January 2020. In MVC 217 of 18, passed by Additional Small Causes Judge and MACT at Bengaluru. Appeal is preferred on the premise of inadequate compensation. Party shall be referred to so and so. Total compensation awarded by the tribunal is 1,09,600 with interest at 9% per annum. Directed the respondent corporation to deposit the compensation within 30 days. It's a vehement contention of learned counsel that the compensation awarded on the lower side, ignoring the materials placed on record, both oral and documentary. The tribunal has not taken the income properly, so also the disability assessed is on the lower side, contrary to the opinion expressed by the doctor. On other heads also, income, the compensation awarded is meager, same requires to be enhanced. Full stop. Accordingly seeks to allow the appeal and enhance the compensation. Per contra, learned counsel representing the corporation sustains the order of the tribunal by contending that no proof of income is produced. Tribunal has rightly taken 7,000 as the income, and the assessment made on disability is also proper, which does not call for interference. In fact, she contends that the interest awarded is on the higher side. Same requires to be reduced. On these grounds, seeks dismissal of the appeal. I've heard learned counsel for both parties. Occurrence of accident, involvement of the vehicle, injuries sustained. The claimant have been proved by production of exhibits P1 to P16. Negligence is rightly attributed against driver of the bus. Coming to the question of age, avocation, income, disability and appropriate multiplier. Age of the claimant, 66 years. The multiplier
5
is correctly taken as 5.
House.
Income taken is on the lower side. Same is enhanced to 11,000 per month as per the chart. Doctor has adduced evidence opining disability to an extent of 12% to whole body, which ought to have been taken by the tribunal rather than reducing it to 10%. Its disability is taken at 12% as expressed by the doctor, who is an expert in the field of medicine. Therefore, the loss of income due to disability would be 11,000 into 12 into 5. into 12%, 79,200. As against 42,000. Para. Towards pain and suffering, 30,000 is awarded. An additional 20,000 is awarded under this head. Towards food attendant, nourishment, incidental charges and conveyance, 12,000 is awarded as claimant was inpatient for 12 days. As against 3,600. Towards loss of income during later period at the rate of 11,000 per month for a period of 3 months. 33,000 is awarded as against 14,000. Towards loss of amenities, 30,000 is awarded as against 20,000. In view of the above discussion, the claimant would be entitled to total compensation of rupees 2,04,200 as against 1,09,600. Full stop. Para. Accordingly, I pass the following order. Appeal is partly allowed. Judgment is modified. Claimants entitled to total compensation of 2,04,200 along with interest at 9% per annum. The balance compensation shall be paid with interest at 6% per annum in a period of 4 weeks. The same shall be deposited before the jurisdictional tribunal. And on such deposit, said amount shall be disbursed in favor of the claimant by way of electronic transfer upon proper furnishing of the bank details. Yes.
Bless.
ಆಯ್ತಾ ಇವರು ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. Just call out. Krishna idara? You are waiting for this Krishna from that time.
My lord,
We'll have it some other day. It's
Yes.
already time. When do you want?
any date convenient to the other side and
Both the learned councils are present due to want of time. List this matter on Tuesday.
Please.
Tuesday, 6th.
I appear for appellant Miller.
ಯಾರಿದ್ರೆ ಇದರಲ್ಲಿ?
ಇಲ್ಲಿ ಬೆಟ್ಸೂರ್ ಅವ್ರು ಇದ್ದಾರೆ.
ಬೆಟ್ಸೂರ್.
ಎಸ್.
ಧಾರವಾಡ.
ಅಲ್ಲ H.C. ಬೆಟ್ಸೂರ್.
ಇದ್ದಾರ ಇಲ್ಲಿದ್ದಾರ?
ಇದ್ದಿದ್ರು ಇವಾಗ ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ಅವ್ರು.
All right.
Please.
Same, list this matter on Tuesday.
Please.
ಶಾಂತರಾಜ್ ಇವಾಗ ತಂದು ಕೂತ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾಕೋ ಈ ಮ್ಯಾಟ್ರಿಗಳಿಗೆ ಟೈಮೇ ಬರ್ತಾ ಇಲ್ಲ. ಅದು 10%
Contributory negligence.
ಮಾಡಿದ್ದಾರೆ. ಸ್ಕೂಟರ್ ಸ್ಕೆಚ್ ಮೇಲೆ ಟ್ರೈಬ್ಯುನಲ್ ಮೆಂಬರ್ ಹಿಮ್ಸೆಲ್ಫ್ ಹ್ಯಾಸ್ hold that there is a 10% contributory negligence.
Doctor has not held.
ಇವರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ has not been stated.
The
with regard-
contributory negligence.
Contributory negligence, 10% ಅಂತ. ಇದು ಒಂದು ಡೆತ್ ಕೇಸು, ಒಂದು ಇಂಜುರಿ ಕೇಸು.
All right. So we'll have it on Monday or Tuesday?
Yes.
Tuesday, madam.
Tuesday. Due to want of time, list this matter on 6th August.
Please, madam. Much obliged.
respondent, my lord. Case of death, my lord.
Also, both of you are ready, Allah?
Ready.
So when do you want?
Monday.
Monday? Huh?
Please, my lord.
All right, at request, relist on 5th August.
What?
Yes,
Appellant, my lord.
yes, Madam Susmita.
Yes,
This also on Monday?
yes, my lord. Any date, my lord.
All right, Monday.
Yes, much obliged.
ಆಯ್ತು. ಓ ಎಷ್ಟು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ದಾನೆ ಅಂತ